All right, I'll consider that.
I'll just give the number to the.
There's a matter of Vidarbha power. There's a matter of Vidarbha power, which is in CRP.
Please, madam.
CRP has to be issued. The matter before my lodge is 109 last week. It's a very short matter. It will decide the fate of the company in future because it has to collect the change in law benefit.
That is a matter which somebody had mentioned. I think
Yes, my lords, I appear for the appellant, my lords. I appear for the appellant, my lords.
And me or Justice
My lords.
Anyway, it will have to be heard by this bench now.
Yes.
Because, all right, Puneet, just take instructions from you.
Dispossession of a residential home, my lord.
May please your lordship, I would like to mention the case titled as Likma Singh through LRs versus Financial Commission.
After notice.
Your lordship, this is a civil appeal which we have. Your lordship, the eviction notice has been passed and the petitioner are directed to evict that particular land by 22nd itself.
By whom?
By financial, actually this is a High Court order which has been passed.
It's a fresh matter.
Yes, your lordship.
Fresh matter.
Yes, your lordship.
All right. Then
And-
it's a civil appeal.
Your lordship, this in this matter, the petitioner was directed to eject that particular land. Actually, this land. Yes, your lordship.
देख लो भाई क्या है.
Your lordship, one more request. Your
Get on with it. We'll list it. Yes. Mr. Shamtanar.
Well, there's a single judge order of the Patna High Court, which has said that there has been wrongdoings in the Bihar Cricket Association with the
Fresh
official
matter.
selection. It's a fresh matter.
Don't be listed.
The first match is on 26th. Now the
Well, I
selection
think
committee has been thrown overboard
Yes.
with some early days.
My lord, this pertains to my life and liberty.
Fresh.
Yes, I've circulated a letter yesterday.
Will be listed. Don't worry. You don't.
I have to surrender before the court.
I'm mentioning,
Will be listed. Don't worry.
I'm so grateful.
I'm mentioning IA in common cause matter. We filed in February. It shows in my case at different time. It's now on 4th November. It is showing on 4th November
It's
now.
already on board on 4th of November.
Let it not be deleted, my lord.
Yes.
This is a challenge to Rajasthan Judicial Service matter. My lords. It is listed
It's on
at
board today.
My lords, 9 more students have approached before your lordship. I have circulated a letter, my lords. It might not reach today, my lords.
Look, we have got about 7 trunks. We had asked for the English essay examination to be, the papers to be produced of all candidates who got less than 15 marks.
Yes, my lords.
7 trunks have come here. When the matter is called out, we'll examine it. You be there when the matter is called out.
Please, your lordship, this is a one more
Already
request.
passed.
Your lordship, the stay shall be granted till the
This
listing of this
possession
matter,
was
your
a
lordship.
Call out, call out.
Your
Lordship's time. Now we have gone. Item 1.
Statutory appeal.
Petitioner.
I do.
Mr. Ramadi, purely a factual question. And these are all rooftop solar installations.
No, with respect, my lords.
And the High Court has said that the 180-day commissioning period should begin from 3rd of May
So that's
2016.
correct, my lords, because the PPA is categorically signed. If your lordship sees the date of the PPA,
It's a possible view, Mr.
well, as with respect, there's a divergence of views, firstly. The KERC held in my favor.
I know, but
Your lordships have already issued notice in a similar matter, my lords, where the same issue arises. That batch of matters, my lords, I'll just pass on the order in a civil appeal. Now,
that was slightly different, wasn't it? Or is it an identical point?
no, one of the points is identical. One of the questions which arises is when does the period of 180 days run?
Panel has clearly found that the commission specifically in this case, para 9, approved my PPA after they had passed the second generic tariff order, which curtailed the first generic tariff order.
but
And
that-
The modified PPA was approved on 3rd of May
that's
2016.
a day after, para 9. So therefore, my lord, even after
The tariff order was 2nd of May.
That's right. So even after curtailing the tariff from 9 rupees to 520, they approved my PPA, which had a 956 tariff.
That's
So
correct.
that's what the APTEL found.
But
Number one.
that is why, my lords, we made a mistake. Just let me just place my point, my lords. If your lordship sees, yes,
I think very important, Mr. Ahmadi, is
yes, my lord.
that you paid at the rate of 9.56 rupees per unit until 1st of January 2017.
That's correct, my lord.
So once you
That
paid him,
We made a mistake, my lords, because, my lords, just let me.
so why should we not give the benefit
No,
to a citizen?
No, with respect, because, my lords, he is otherwise getting a windfall. The tariffs are fixed, my lords, depending actually,
Why did you pay him until 1st?
because we made a mistake, my lords. Now,
Now continue the mistake insofar as he is concerned. Why should we
May I-
ultimately, look, Some fairness to a citizen also has to be.
So now just let me place the point.
Previous tariff is not out of the hat. It's based on
Let me
generic
just place
tariff
the
order of
point,
the
Manoj. I won't take more than 1 minute.
Yeah.
Let me place the point, if your lordship permits. Now, Manoj, the guidelines make it clear. The guidelines are 7/11/2014. If your lordship sees page 88, the guidelines make it clear that the commissioning must be within a period of, Manoj, 180 days. Now, kindly see the facts of this case. The first PPA with him, Manoj, is 31/1/2015,
Correct.
which is only, Manoj, for 50 kVA. Your lordship gets that? For
That is
500.
for 500 km.
Correct. Now, we give him the first extension on 5/7/2015.
Give him multiple extensions.
Multiple extensions. Now, Manoj, finally, the PPA is inked with the enhanced extension for 1000, Manoj, on 5/1/2016 for the enhanced capacity. That's page 20. It's my case, Manoj, that the period of 180 days will run from the date of the PPA. That's my case on law.
But the modified PPA
Yes.
was approved on 3rd of May 2000.
But before that, he had not understood that to say that I can't do any work. On 4/4/2016, there is a report that he continued with the installation even in the meanwhile, page 126. After that, Manoj, now just see the express terms of, Manoj, the modified tariff order. If your lordship will be pleased
What
to
does it
see,
say?
page 135.
What does it say?
It expressly says, Manoj, that so far as new PPAs which have not been commissioned up to the date of the tariff order and which are to be commissioned in future, those PPAs will get.
But see, his PPA was in January,
That's correct.
though it was approved on May. Therefore, once the approval comes, it relates back to January.
No, with respect, Manoj.
That's the point.
With respect. Just see the terms, Manoj. Just see the terms of the tariff order at page 100 and just see one page, Manoj.
What is the total quantum?
2 lakhs a month.
No, Manoj. It comes to approximately the overall financial liability is 13 crores. And it's only not limited to this case, because what happens is,
See, the thing
because
is
they
that
are getting,
on the one hand, we say rooftop solar.
because they are
people
getting,
do this in
because
high
let me
street.
explain, they are getting a windfall for this reason.
Somebody makes a windfall. That's what business is all about. But question is whether we should interfere merely because he's getting some financial.
So the question of law that arises is just see, Manoj, the express terms. Just see the express
Thank
terms, Manoj,
thank you,
at page.
Mr. Amari. We've crossed the 1 minute. Thank you.
As your lordship, please.
But the moot question here, my lord, was striking at the root of arbitration law, my lord. Whether, my lord, they're in an admitted situation where, my lord, even prior to commencement of arbitration,
Arbitral award.
I
34
admitted the
34
liability.
34 dismissed and 37 dismissed.
my lord, all along, the problem is that all the three forum, my lord, did not address this issue.
Something has to.
For
rest
different
now.
purposes.
There's an arbitral award.
With greatest
After
respect,
the
yes.
34 has been dismissed,
Yes.
the 37.
But not lordship will see that neither of the forum below address this issue. And my lord, it is very fundamental. Lordship have already taken a view.
And
that
your
when there is no-
your only contention is that because your payments from BSNL were held up,
Not that-
therefore you will not pay him,
My
therefore
lord,
you are
I did
delayed.
not
How is
say-
it concerned?
my lord, kindly see, with greatest respect. What I said was, may I only say this?
Yes.
My lord, my contention was not that my liability is dependent on payment.
Your contention really is that
Yes.
because the payment which is due to him is admitted by you,
By me.
therefore there is no dispute.
There is no dispute.
But what is it, Brother just Manoj Mishra just mentioned, the words used are breach. Now, breach is wide enough to comprehend even non-payment of an actionable claim.
My lord, it is like, but
would it not
when
be
we,
very technical
Lord-
for your, look at your client's contention. You said, look, I have admitted my liability towards him and therefore there is no arbitrable dispute, you say.
yes.
How can that?
My lord, may I only answer it like
On
this?
this point,
May
look,
I only
on
answer?
this point,
May I only
you are
answer?
under 136.
Yes.
On this point,
Yes, my lord.
three forums are against you. We are in a situation where there's an admission of liability by you to him. You say, because I admitted my liability, therefore there is no dispute. Can this be?
My lord, may I only make two submissions? My lord, may I make only two
Also
submissions?
for justice.
My lord, may I make only two submissions? One is,
And even on law,
Yes.
you're not right because the word which is used is breach. breach of an admitted liability would always also give rise to a dispute within the meaning of.
With respect, Lord, if we look at section 7 of the Arbitration Act, it says there has to be a dispute. I am saying I have to pay. And I have given much prior to commencement of arbitration, Lord, I have given a schedule.
We can't give you such a narrow view which will defeat the purpose of the Arbitration Act.
And then, Lord, there is a contradiction also in the award itself.
Thank you.
May I just say, Malas, one thing for my satisfaction? Gratefulness.
Lord, Lordship has already taken a view on this.
Not at all.
There is a judgment which is not even adverted to by the Honorables.
Thank you. Item 3.
Lord, here the
Yes, Mr. Mehta.
Lord, here the question is, my lord, whether the state government, with regard to its sales tax,
To notice here, because question is whether sales tax dues of the state government will rank over the IBC.
correct?
You are for the government,
Yes, my lord.
and you are saying that you are relying on rainbow.
I am relying,
Today, there is a rainbow is up for consideration before a larger bench, I think.
Lordship,
Anyway, we'll issue notice. It's a question relating to issue notice.
obliged.
No, sir, we'll not entertain this. Thank you. You're saying that, you're saying that the term Hindutva should be replaced with the phrase Bharatiya Samvidhanatva or Indian Constitution.
So, please grant me just 2 minutes to make my submission, sir.
No, sir.
Just 1 minute, sir.
This is a complete abuse of the process. Dismissed, yes. Item 5.
It's a fresh matter. I am praying for some time to file documents to prove 2 things, my lord. One, that the consignment booked was admittedly overloaded.
One, what you are saying that in ground A, you have said that the judgment of the High Court is per incuriam in view of their own judgment in Union of India versus Meghalaya. Are you pressing that ground or no?
Not that also, because at page 103, the Honorable High Court by coordinate bench has held that the notification of 50 stations is not confined for charging
How much is the total amount involved in this case?
1 crore 56 lakh odd, my lord. And I also need to place on record circulars which say that 50.
The High Court says that you cannot charge punitive charges after unloading of the goods at the destination.
Not for that purpose, I have documents to show that the consignment book was overloaded. That would go a long way to charge overloading charges.
You should not have permitted to upload the goods in the first place. Why did you permit it?
That was wrong, my lord.
That's all finished.
But not overloading charges, if he has booked.
5 and 30, therefore, we'll dismiss. 30 is the same, no?
Yes, my lord, same.
5 and 30 will dismiss, yes. Yes, Makija, the property, the hotel premises are in Ahmedabad. Parties are from Ahmedabad. It says that the place of arbitration shall be New Delhi, and they have appointed a sole arbitrator.
That's immaterial, your lordships, because
The juridical seat will be Ahmedabad, actually.
it won't be, your lordships. That's completely immaterial. Once there's a party autonomy, once there is a clause of place of arbitration, after BGS and BBR, your lordships.
What difference does it make whether the
It makes a
arbitrator is
difference
appointed by the
because
Delhi
the
High Court
whole
or-
law, which was clarified in BGS SOMA, will be upset.
You entered into a sublease for a
Lordships,
hotel
that's
premises
the
situated in
point.
Ahmedabad.
Lordships will kindly see my arbitration clause. Give the chart, no? Lordships may kindly see this. This is a conflict legal position.
14.3 expressly uses the word place.
I'll just explain to your lordships what the law is and relegated to a law which was prior to BGS SOMA. Lordships may kindly take this chart. This is the conflict of views, and these are all the views which have been held and concurrently held and followed after BGS SOMA consistently.
Say about clause 16.6.
I'll explain that because BGS SOMA very clearly clarifies that if there are two clauses.
Consequence arising therefrom shall be governed by the laws of
Absolutely.
India
So that is,
and shall be under the jurisdiction of the courts at Ahmedabad.
that is exactly what is explained by Justice Nariman in BGS Soma. He says that there are two clauses, two sections. One is section 20, subsection 3, and there is a section 2, which defines court. These are for two separate purposes. As far as venue and seat is concerned, it is connected to party autonomy. And the arbitration and challenges to arbitration, the appointment of arbitrator will all be relatable to the place which is equivalent to the seat. Now, this is the view which has prevailed now. And prior to this view was that if there are two jurisdictions, that was the Balco view, that if there are two jurisdictions, then either can be invoked. This honorable court has said,
Been looked at also by the.
no, it cannot, your lordships. Let me just,
Ultimately, you know,
lordships will give me 2 minutes. Lordships will see
but look
what
at
lordships have held.
we have to always make business sense out of any contract.
Business sense
Now,
only, your
parties are
lordship.
based in Ahmedabad.
Business
The
sense
SPL
only.
is based in Ahmedabad. And third, clause 16.6 specifically refers
It's the
to the
jurisdiction
court.
clause. It's not the arbitration. And let me just show to your lordships.
This place as a
Lordships, this will create havoc. And if your lordships will just
Nothing will-
give me the indulgence of taking this chart.
And you're going to have an
Consistent.
arbitrator appointed who's a former district judge.
Your lordships, that's besides the point. The point is this, that
You
I am a
delay
national.
the proceeding, that's
No,
all.
I don't want to delay. Your lordships will appoint an arbitrator. Today, I will go to the arbitrator. I do not have a quarrel with application, appointment. In fact, I want an arbitration. I have
They've
consented.
appointed an arbitrator. You're not saying that arbitrator is biased or something like that.
An exercise of jurisdiction, which is contrary to the
No,
law,
miss.
itself goes to,
They will-
lordships will give me 2
Thank you.
seconds.
No, we'll not interfere.
Lordships-
Item 7. No, Miss.
Lordships will just look
No,
at
not at all.
para
We
82.
also have to look at the justice of the situation.
Lordships will kindly see.
Merely because a point of law is made, we don't issue
It's
notice.
not a question of law. I'll tell
Thank you. Thank you. Thank you.
Just give me a minute, your lordships. The reason why I'm pressing is
Not-
for a particular
not the-
reason,
Not a-
not to concern with my
Thank you.
parties.
Item 7, yes.
The lordships will then clarify.
Item 7 will issue notice on delay and tag it with that other matter. Which
Your lordships, may I just clarify,
thank you.
seek
That is
for
over.
clarification,
No,
because
thank you.
now,
Item 8.
I approached the High Court.
On the other side,
I don't think, my lord.
Bombay High Court, we had a very distinguished judge, Justice Dhanuka, who used to say, operation successful, patient dead. You went only for an order for expediting the hearing before the DRT. The High Court, in your petition, sets aside the orders in your favor, which were never questioned by the other side.
A blind man goes to the.
You know what? I read your petition twice over because I couldn't believe what I saw. I said, maybe I've read it wrong. So I read it a second time because it was issue notice here.
Please, my lord. Please.
And serve dusty and come
That's
set
the
aside this
order.
order and send it back.
Oblige, lord. Yeah.
Stay the order, by the way. We'll stay the order. Impugned order shall stay. Stay. The grievance of the petitioner is that in a petition which was filed by the petitioner under Article 227 of the Constitution for expediting the hearing before the Debt Recovery Tribunal, the High Court has virtually concluded the issue on merits that would have arisen before the DRT, though the orders which were set aside were not impugned, were not questioned by the respondent. Issue notice and stay.
Eight. Nine.
Now, the notifications of 3rd of November and 15th March are in question before the NGT, the High Court has recorded.
Yes, my lord. That is a question before the NGT.
But here, in the same matter,
issue notice here.
the same interim order may be granted, that is on phase.
We'll say notice on interim relief, serve them, thus the income. Yes, item.
They have already operated the mines also, they have pissed off. Even single day they cannot operate the mines because they have.
So we are issuing notice, serve them, thus the income. We are issuing notice on interim relief.
When interim relief may be granted for.
We're just saying notice on interim relief. You have to hear the other side, that's all. Ms. Jaising, what is the interim relief that you are seeking?
My lord, the interim relief application is there on the record.
Just tell us, are you at
The operation of the letters of.
dated 7th June 2024?
Yes, my lord, because
No, just tell us, because for our order we need that. 7th June of the NCPCR.
Be acted upon, my lord, because they are being acted
Just
upon.
give us the dates for our order.
So it is 7/6 and 25/6. Prayer number A at page 69.
Issue notice, returnable in 4 weeks. Pending further orders, the letters, the communications dated 27 June 2024, issued by the National Commission for the Protection of Child Rights. 7 June and 25th June, right?
Yes.
Both by the NCPCR.
Yes, my lord, those two dates.
And what about the communications of 26 June of the Chief Secretary?
Consequent upon those two letters. So obviously all consequent.
And all consequential steps taken.
B, C, D, E give you the letters.
Pending further orders, the letters, the communications dated 7 June 2024 and 25 June 2024 of the National Commission for Protection of Child Rights and the consequential communications dated 26 June 2024 of the Chief Secretary of the State of Uttar Pradesh and the communication dated 10 July 2024 issued by the Secretary, Department of Education and Literacy, Ministry of Education, Government of India, and 28 August 2024 issued by the Directorate of Elementary Education, Government of Tripura, shall not be acted upon.
I have a small request to make, my lord. Obviously, the directions dated 10/7/24. I have made only Uttar Pradesh and Tripura parties because they're the ones who have now issued circular. Your lordship will be pleased on my oral application, allow me to add all states because all states are going to be doing the same.
Oral request of Ms. Indira Jaising, then Senior Counsel, liberty granted to implead all states stroke duties. The notice issue.
We have to amend.
Yes,
and
we
these
comment.
directions will
Will be
apply to all
carried out
states.
within the course of the week, and then you can say pending further orders, the order ho gaya, and you can save liberty to serve the standing counsel appearing on behalf of the state stroke duties and the central agency for the Union of India.
Deeply obliged.
My lords, the in item 41 is a recognized madrasa matter. Listed today. It's listed today. The recognized madrasa matters is also listed today. So
That's not
it. Yeah, it's fine.
appearing in item.
Yeah, it's fine. Lords, 41, my lords, today is the recognized madrasa matter in which this is the matter pertaining to all recognized madrasas.
That will deal with Bennett region.
Yes, so pleadings are complete in
Yes,
this.
item 11.
My lordships will hear that.
I think 11 you should consider, this is a case where the funds are collected from the consumers, invested by the state.
Yeah.
Lord, I appear for
Or
the
the
contesting
interlocutor.
respondent, my lord. Lord, the
PDF rule itself says it has to be by way of investment by equity. Kindly.
You file your response. We'd like to consider this.
But then
Notice, sorry?
an early date returnable.
Yes, after 3 weeks, you file after Diwali. You file your counter, we'd like to hear you for maybe half an hour, we'll hear you for 15 minutes and then decide.
Deeply.
Notice also on the interlocutory?
Sorry?
In the IA also?
Yes, we'll hear them. We are not passing any order, you file your counter.
Lordship, please.
Deeply blessed.
Item 12, this has to be tagged, right? With
Quite so,
RBI versus
Quite so.
issue notice and tag.
Well, it's just one small request. I appear on behalf of DBS Bank in the previous matter, which was tagged on the 30th of September. The order by inadvertently records
my appearance had come in place of DBS. I'm appearing for RBI.
That's the only
Different
small.
Can you just do this? Can you come in the morning tomorrow or just at 1 o'clock? We'll just do it. We'll take it as a mentioning and correct the. It's only the appearances.
Only the appearance.
Only the appearance.
In the text of the order, my lords.
Also, my appearance for RBI has been given for DBS. So there's
what is the clarification that we have to issue notice?
That's para 4. Mr. Raghav Shankar appears on behalf of RBI.
But Mr. Navneet will accept notice on behalf of RBI.
The court
will issue a revised. We'll hand it over in writing.
Would your lordships kindly consider condoning delay also?
Well, as in 12.1.
12.1.
Mr. Nankumar is appearing in.
How much is the delay?
54 days, 57 days, I sent.
Yes, you can do
it.
My lords, it's for hybrid mode of hearing by the family courts to get over the financial and logistics.
Governed by the provisions of the state courts. The family courts are not standalone courts.
My lord, they have been appointed by the state government, my lords. They are appointed by the state government under the Family Courts Act 1984. Therefore, they act independently, and it is not. They don't come under the High Court that way.
Notice, Mr. Jain.
Oblige, my lords. My lord, returnable.
Yes. Item 14.
In a review petition, and without even noticing the relevant regulations, relying on some regulation which has general application, but there is a special regulation, page 356, in regard to DVC.
Can you just sort of explain to us, maybe in a nutshell, what is the issue really? Because I was also wondering how in a review petition they did all this.
Depreciation has to be allowed anyway,
right.
And there is a sinking fund in regard to DVC because of the historical.
What Apple seems to be suggesting is that since the bonds which are issued by DVC, your client,
yes,
from time to time, are redeemed from the sinking fund, which is created under section 40.
Factually incorrect as found by the original judgment. In the review without even any consideration, it's allowed. And please see the relevant regulation.
The sinking fund is not created by you from the tariff realized from the consumers?
No.
How is the sinking fund created then?
356.
Because at page 24,
yes,
the tribunal holds that since it is created under section 40 from the tariff which is realized from the consumer, therefore the capital asset created through such bond amount does not qualify for depreciation as a pass-through tariff element. That's the
original judgment. This aspect is considered and said that these are not the funds which are used for the purpose of creating the capital asset.
In 2018,
yeah,
that both recoveries
and they
just make us stand 33 and 34 of this impugned order. Just make us understand.
Yeah. Now, please see first.
Yes. And just make us understand what is the
reasoning of the tribunal is in the review petition. The earlier judgment of the Supreme Court did not go into the duplication.
It says it cannot be gainsaid that redemption of bonds from contribution to sinking fund is a special tariff element provided to DVC under section 40 of the DVC Act. So something to do with interpretation of this provision. In addition to the tariff elements provided in the tariff regulations issued by the Central Commission from time to time, there is nothing in the above noted judgments of this tribunal and of the Supreme Court that depreciation shall be allowed on the capital assets created by utilizing the bond amounts. What is it trying to convey?
Now, the question, this specific question is raised in the earlier round at page, kindly have a look at page 155, 156, para 25 of the tribunal.
What the tribunal seems to be saying is that a distinction needs to be created between depreciable assets created by the use of the bond fund and depreciable assets created by the use of funds from other sources. If you accept that.
Can I just add, Lord, permit me? What happened, Lord, when this DVC was initially set up, the government didn't want to fund it from its own money.
Right.
So the government decided that there'll be a sinking fund for the original capital asset, not depreciation comes much later. Your lordship knows. So the original capital asset was set up on the basis of which fund, and section 40 of the DVC Act said that this fund will be, the servicing of this fund will be by the tariff. So that was the original asset when it was created. Depreciation under the regulation, your lordship knows, is for the use of the asset and its replacement value whenever it will happen, maybe 15 or 20 years later. So depreciation has been separately provided for by the Act, again by the Act, DVC Act itself. So sinking fund, the original creation of the asset, and depreciation for the replacement value of the asset whenever it will have to be replaced. That is, replacement is not done by the fund. Replacement is done on the basis of the depreciation only. And replacement has not even happened today. Replacement will happen at some stage because these are all funds which was taken between 70.
And the tribunal now in review holds that you will not be entitled to depreciation on the sinking fund.
Correct. On the sinking fund.
Because originally when it was created, it was out of the tariff.
This and kindly see the relevant regulation.
What are you saying? You're just
this court, this issue actually came right up to here. 2007, Lord Justice Anil Dev Singh, when he was sitting, Lord, in the appellate tribunal, said that they are entitled to both the sinking fund also as well as the depreciation. One private party came here, and Justice Gogoi's judgment in 18 said that yes, these are both statutory entitlements of the DVC, and they are
so
not
irrespective of the source through which the sinking fund arises.
That's right.
Namely, this a tariff pass-through element.
That's right.
Because it is really a depreciable asset. The sinking fund itself, you have.
Depreciation is provided for in the regulation.
All right, what we'll do is we'll hear the other side. Maybe
Lord,
we'll see.
Will have to be granted. Otherwise, Lord, the whole my whole accounts will be going for a toss.
But the orders of what we'll do is we'll issue notice on interim leave.
But
keep it after 2 weeks.
These orders have been in existence from 2004.
We'll keep it right after Diwali. What we'll do is we'll keep it.
Will start, Lord, the whole thing will start.
We'll keep it right after Diwali, serve the other side and come.
Very well. But status quo is
we'll keep it right after Diwali. Let's issue notice on interim leave and hear them. Yes, serve them dusty. Item 15. Yes.
Excuse me. Your Lordship,
The main matter is pending here. This is an execution.
The execution is disposed of. The 34 is pending. They moved a stay till date. 5 years have passed. No stay has been granted by the 34 court in a 36 too. So if my learned friend just says the 36 court said that at the moment, there is no reason why the execution should not be allowed in the matter. And that's all, and it's all subject to the outcome of the 30.
I think this Tata Motors versus DTC has come to us so many times, I think. Previously, we have dealt with this. There's a dispute on different phases. It may not be in this case itself, but ultimately, it's Tata Motors. You'll get your money back. Where are they going to run away if they get it?
The order says so. The order says it is subject to the outcome of 34. Even the earlier amount released is against bank guarantees. And this also the court says is subject to outcome of 34.
Court says, right or wrong, I have to execute the award.
Right. There's no stay.
The statute says so. The statute is.
It's an executable decree now.
Unless it is state, it shall be executed is what the statute says. That's the mandate of the statute.
See, these are not fly-by-night operators, that you're completely gone forever.
Raise this interest on which the statute itself provides.
Your Lordship will have.
You notice that's the only point, really.
Yes, so on that, my lords, they fall into the error of relying on D coastline.
Their argument was that from subparagraphs D, E, F, H, I, and K, interest should be excluded from the 18% award, but the award doesn't say that.
Not only that, the statute says, if your lordships were to see the provision specifically provides under both the categories, just have the provision is 31(7) A and B, if they are to be seen, categorically say interest from the date of the cause of action till the date of the award, and 31(7) B says that post-award interest on that entire amount can be granted. Now, D. Khosla was a case under the 1940 Act where this interest was not provided for. So the Supreme Court in that judgment said that unless there's a statutory scheme, the decree holder can't ask for interest on interest. That was the case. So that is why the executing court rightly says you are citing a D. Khosla judgment, citing a line out of context to say no interest on interest. That very paragraph says that if there is a statutory scheme,
It's an order passed. It's an order passed in execution. Why should we interfere?
Your Lordship will appreciate our principal amount is 296 crores. We have already deposited 340 crores. Your Lordship will appreciate on only 100 or 120 crores is left. My Lord will appreciate 23 times my stay application has been.
That's why arbitration must have some sanctity. Why should we today interfere?
In every matter, this is what happens.
And ultimately, whatever you pay will abide by the final result of the 34 which is pending.
And your Lordship says so.
Your Lordship will accommodate me till 29th November. It is listed for final disposal on 29th November, section 34.
That's all right. That who knows whether it will be listed on 29th of November, heard on 29th November.
My Lord, may kindly pass a direction in this regard. My Lord, 29th November, it will be over.
It's a money decree. There's no stay. Let them have the benefit of that. And if you succeed, you'll get the money from them.
My Lord, heavens are not going to fall when we have already deposited this much.
It's a money decree in their favor.
A profit-making venture.
So what? But for them, it's a profit-making venture, and we must therefore have respect for the fact that you deal with entities which are in it for the business. They are investing money.
It's a 2017 award. For 7 years, you withheld that money.
All right, sir. Dismissed.
Grateful, my lords. Very grateful.
Lordship is this.
16?
But I appear, my Lord.
Why should we interfere at this stage? You have an appeal.
No, but kindly kindly give me 2 minutes. Earlier,
it's an assessment which you can always challenge an appeal, Mr.
My Lord, but this is during the Corona period. I have not been able to give answer because I was given 2 days notice. All high courts across the country have taken a view. Giving 2 days notice is not enough. Sir, earlier 3-4 notices I replied. At the time when the last notice is received, my chartered accountant is hospitalized. He has a bypass surgery. He is in hospital.
They're all, it's an order of assessment under the Income Tax Act. You have a remedy of an appeal before the CIT appeals, then the ITAT, then the High Court. You want to sort of just completely make a short circuit by filing a petition under 226. Against the order on merits, and you say natural justice, argue it in the appeal. Tell her, dismissed, yes.
Court has, every honorable High Court has interfered.
Will not interfere. Item 17.
Because in item 17, the parties at the time of entering into the contract quantify damages at double the amount. So from 3 lakhs, it becomes 6 lakhs.
If you have succeeded
in part, he has reduced it from
17 lakh 95
down to 11 lakhs 51,000.
Mr. Diwan,
yes.
5,700 square feet at Rampart Row.
Yes, so there your lordships have seen. No, but your lordship saw the findings of the High Court itself, saying that, look, there is no access to this particular road. There's a small gully over there, etc. And the building is not in mint condition. That's the expression used. I am just making a suggestion. When the 2 points, well, I have only 2 points. Point number 1 is that the agreement itself said that if you stay beyond the period, because I'm asserting that I'm a statutory tenant, is double. Now, the double amount is 3 lakhs is quantified in the leave and license agreement. Double becomes 6 lakhs. 6 lakhs is what has been provided till the date of the decree. Now, the question is only
post-decree.
Post-decree. That's all we're concerned with.
Been asked instead of 6 lakhs to pay
11 lakhs 51,000.
The date of the decree?
Yeah. The date of the decree itself is 17 December 2022. 17 December.
From 18 December 22, you'll have to start paying at the later.
Yes. So, Manoj, I have only 2 points. One is 6 lakhs may be maintained. That's my first point. The second point is, and we've set this out, Manoj, in our synopsis. The measure used by the Bombay High Court is 6% of the ready reckoner rate. That ready reckoner rate, I've quantified it. Manoj, I've put it in the list of dates. Please see page O and P.
So, Diwan, what is that in 136 for us?
6 lakhs, Manoj. It should be maintained at 6 lakhs is our request.
Leave it, Mr. Thank you.
Very well, grateful.
Item 18.
Would your lordships just extend the period by 3 weeks for arrears from today?
Time for payment
of arrears.
We do not find any error in the. There's no error in the impugned order of the single judge of the High Court of Judicature at Bombay, dated 27 September 2024. The special petition is dismissed. However, time for payment of arrears is extended
3 weeks from today.
By a period of 3 weeks from the date of this order.
Yeah, please, grateful.
Item 18.
What is regarding non-adversarial litigation regarding e-copying it is permissible for third parties through physical filing but not through virtual
Petition, writ petition, criminal 552, that's on a separate point, right?
552 it's my writ petition where I am the petitioner which they say I am eligible to file through e-copying
E-copying facilities to be made.
But if I file for some other matter where I want to implead or intervene, if it's a pending matter, I want to.
Notice, yes. We'll issue notice.
Much obliged. May I say one small out of time request because at the mentioning stage I was cut off. Lordship may consider life-saving treatment for my child.
May it please, the predicate offense goes. If your lordship kindly sees page 111, the ECIR is registered on the basis of the predicate offense, which is FIR 163 of 2018. In that, a closure report is filed in 2019, accepted by the magistrate on 18th of April 2022, has attained finality.
You didn't challenge it?
Nobody has challenged it.
You are the first.
No, 163 of 2018, I was the FIR informant. Then what happened was, based on the further investigation, the auditor of that local cooperative service bank got 3 more FIRs registered, in which one of the FIR is against me. I am the original FIR informant. And what ED does is, after the predicate offense, which admittedly in their EC, it's an entire role reversal from being the FIR informant. I've now been roped into this entire allegation.
For a moment before we continue hearing it.
Yes, Your Lordship. Lordships, the judgment of Your Lordships in Vijay Madan Lal Chaudhary, it considers 3 points, Your Lordships. One, that is if the person is discharged in the predicate offense. Second is the acquittal, and third is quashing. In this particular scenario, none of these 3 are applicable because there is a C summary which has turned in this particular case. Now that aspect was not considered in Vijay Madan Lal Chaudhary. Therefore, the High Court says when 3 of these are not to be taken into consideration for this particular case, then we have to differ from the judgment of Vijay Madan Lal Chaudhary. Vijay Madan Lal Chaudhary also considers only 1 FIR. Now here what has happened is there was predicate offense of 1 FIR in 2018. After that, before this particular FIR turned into C summary, 3 more FIRs were filed by the statutory authority, that is the registrar. Now the ED says that these 3 FIRs have been subsumed in the original FIR of 168 of 2018. So therefore, there are 4 FIRs at this point of time. Now, even if the 1 goes, 3 remains. So therefore, the ED can continue with the investigation.
How are these 3 FIRs subsumed in the first FIR?
Because when the first FIR of 168, they started with the investigation. Now, during the investigation, there are number of FIRs which have been filed. This is with respect to that Seva Vikas Bank. Your Lordships will have already considered.
Are you supporting him?
No, Your Lordships, I'm not supporting. I'm saying, I'm the victim, I'm the complainant, original complainant.
The complaint.
Yes,
I'm not for the complaint.
I'm also the FIR info. The original, the predicate offense which was based on the FIR is based on my complaint. He is on a subsequent complaint.
Now, who lodged the first FIR?
I lodged it.
He
And then there was 3 subsequent FIRs.
subsequent FIRs.
In which you are the complainant.
No, my complaint is the different, that is 806 of 2019. That is also subsumed in this ED proceedings. Now these 3 FIRs are by the registrar of the societies.
Oh, I see.
It is the statutory FIR.
Right.
So these FIRs say that there is a scam and 3 groups have been made. One of the group belongs to the petitioner, wherein he is also made an accused.
Right.
So therefore, the ED also says that he is one of the beneficiaries of the proceedings.
May I just respond to that straight away? May I just respond to that straight away?
When this ECIR was registered in pursuance of that FIR, ultimately C summary was filed.
Yes.
That attained finality.
Yes.
So that ECIR has gone. That is how this man is aggrieved, this man.
Yes, yes.
But there is no fresh ECIR so far as the other 3 FIRs are concerned?
No, because
why?
I'll tell you the timeline, how the timeline goes. The FIR is of 2018. The ECIR is of 21. The C summary has culminated in 2022. So before there is a C summary, there are 3.
This C summary takes care of the other 3 FIRs
No,
also.
no. It only is with respect to
about the other 3 ECI.
other three FIRs was subsumed in that proceeding.
But what is this subsumed? What do you mean by subsumed?
Yes,
So
that is the
question. That can't be subsumed.
Therefore, Your Lordship, the High Court has considered this aspect, and High Court has said that when the first FIR was live and kicking, that is the 18 till 22, these 3 new FIRs have come into effect, which were part of the ED proceedings.
What happened in those 3 FIRs?
Those are still pending.
Yes,
still going on.
But there is no fresh complaint under PMLA.
No fresh complaint.
May I just respond to this? First and foremost, this entire concept of subsumption is not there in the PMLA, and neither it finds any recourse to any of your lordship's judgment. This is an absolutely virgin area of law. Whether can the ED subsume downstream subsequent FIRs? That's my first answer. Second, Vijay Madanlal. I'm so sorry.
Yes, yeah. Really,
Very well. Deeply. I'll respond.
Item 20.
Obliged.
What is this now, Mr. Manikandan?
Yeah, please, my lords. This matter had come up last week. My lordship wanted to study the situation where my lords take up the matter, because your lordship pointed out 2 things. Your lordship pointed out that the Supreme Court does not come under the committee project, my lords, for which I had an alternative suggestion. I wanted the lordship notes.
21. Yes.
My lord, this is for extension of time by the learned district judge for carrying out the computation, my lords.
That's all. This is only for the extension. This is for extension of time for
carrying out the computation in terms of the arbitration award, my lords.
Then we'll extend time by a period of 3 weeks.
My lord, 6 weeks, my lords, we do 6 weeks because.
All right, 6 weeks.
Lords, liberty to the parties to apprise the learned judge, my lord.
It's always there, yes.
Item 22. My lord, 22 is that matter of SIDCO, where your lordships were prima facie not with me. My lord, yesterday I had a detailed sitting. My lord, the officers were also there. And my lord, it was my mistake. I could not point out certain things which would go to the root of the matter. I'm saying that with a sense of responsibility. But I have prepared a short convenience compilation. But some documents are new,
Some are, my lord,
We have a slightly heavy board today. This might
take it up on, my lords.
Monday after we reopen.
Please.
Monday after we reopen.
Yes, yes.
Accompanying
no difficulty.
A small fry, not they want the big fry.
All right, we'll see. We'll also see his note. We'll take it up on the Monday after we reopen.
Lord, there is
Malas,
a.
may I file a compilation, Malas, because
You can
there are
also
certain
file it.
maps that have not been filed on record.
All right.
That will
Yes,
clear
yes,
the
sir.
air.
All
I'm
can.
so grateful.
All can.
I've got a map ready, but I can
There are
explain
some
it.
additional documents on our side as well.
Time we have a heavy board today,
Yes, yes,
so we'll
Lord,
just
Lord.
not do it today.
Additional documents.
No problem.
Item 23.
Can we find additional documents?
You can do it. Not difficult.
Great.
In the accompanying essay. Grateful.
I'm so grateful.
So I beg to appear, Madam. If your lordship sees the relevant rules.
It says that, if you had got the 15% all India quota, then you would be eligible to apply. Now, you didn't get the 15% all India quota from a government medical college, AIMS, or central government institution. You went to Vellore.
Well, there are two
That's why you have been.
Yes, so there are two aspects, Madam. First, your lordship may see 8.2 at page 43.
8.2.
And your lordship may only bear in mind one aspect, Madam, that this is a PG course.
We heard this, ma'am.
We heard.
Yes, Madam. So your lordships were pleased to, my lords, observe at that stage that perhaps you should challenge 8.2 also.
So now you have
which I
therefore.
have done. Now kindly see, my lords, what 8.2 says.
Page?
8.2 at page 43. What's the PDF page?
PDF page.
PDF page?
Just give me my page. I'm asking you for the PDF.
You can read page 11.
Yes,
Main diary.
Main diary.
lordship, please.
Where is it? Page 43.
May I read that, Madam? I should always keep PDF. Sorry, Madam. I today don't have my iPad. I apologize.
Yes.
I'm obliged. This is a condition of eligibility. All candidates who pass the final MBBS degree course examination from the college situated in Maharashtra state and completed 1 year internship training by 15th of August 2024 from a recognized medical college included in the schedule as per the provisions of the NMC Act 2019 and the repealed Indian Medical Council Act 1956.
8.3 relaxes the rigor of 8.2.
Yes.
But it says, because 8.2 says you must have passed your MBBS degree course from a college in Maharashtra. Affiliated to the.
That's correct. And
university.
8.3, what it says is, you must have two criteria. One is that you must be domiciled in Maharashtra. And the second criteria in 8.3 says, and you must have qualified from any of these three institutions.
15% all India quota.
From any of these three.
Government medical colleges, AIMS, or central government.
That's correct.
Now you did your UG from Christian Medical College, Vellore, which is not one of the three.
Yes.
That's the point.
Now, Christian Medical College, Vellore. Now, firstly, so far as the merits of the student is concerned, they are outstanding. Christian Medical College, Malas, Vellore, as your lordships are aware, ranks amongst the top 3. Now, I had even got into JNU. If I had taken JNU at that point of time, I would be, at that point of time, you had no such regulations in 2016, when I opted for Christian Medical College, Vellore. So I could have easily got into JNU. I also got into KAM in Maharashtra. But because I was getting something much higher in the All India ranking, I took Christian Medical College, Vellore. So my first submission is, Manoj, that 8.2 for a PG course, to the extent that it provides this particular criteria, that you must have done your medicine, Manoj, only from a particular college in Maharashtra, on the face of it is manifestly arbitrary.
Why? Why can't the state not say that, look,
yes,
you are now applying for a seat in Maharashtra from a government medical college in Maharashtra?
Yes, yes. my lord.
Right?
Yes.
Why can't they say that we will confine our admissions to those who have done their MBBS from our state?
So one is, my lord,
Otherwise, students from all over the country
No,
will come there.
then you can have a criteria of domicile. I am in Bombay. The criteria of domicile is one thing, Manoj. To say that there is a criteria here today, Manoj, you are eschewing merits for a PG course. I can understand undergrad. Undergrad, Manoj, several other aspects come in. But so far as a PG course is concerned, that's a speciality. Second is, Manoj, your lordship's judgment in 2013 10 SCC, page 237, paragraph 16 and 19, specifically deal with this particular clause.
8.2 says all candidates who have passed the final MBBS degree course examination from a college situated in Maharashtra state
Yes.
and completed 1 year internship training by 15th August from a recognized medical college, etc., are eligible.
Yes. So
Now,
if
they want to ensure that, look, these PG seats are limited.
Yeah.
We want to, as every state wants to restrict it to those who have done their final MBBS from their state. They don't want people from
Yes,
outside
now,
state because these are very limited.
So I am not outside the state. I am domiciled in Maharashtra.
Right, but you never completed your MBBS file.
Maybe,
you went,
Manoj,
you
because
went
at
somewhere
that
else.
point of time, you didn't have this kind of a clause. I wanted to do my PG. I wanted to stay there. I got it in an all India ranking at number 3. Now kindly see, my lords, this similar clause has been construed by your lordships. In, my lords, this judgment, if your lordship sees 2013 10 SCC, page 237, we have a compilation. Now kindly see, my lords, this judgment, if your lordships
Wrong about a state saying that you must have passed the final MBBS degree with from
Because
within the state.
for a PG, my lords, that has been struck down. Just see paragraph 19 of this judgment. Well, I can understand undergrad, but you can't really compromise merit. You can't compromise merit to this extent. I can understand even limiting it to domicile. Now kindly see, my lords, this judgment, my lords, 2023, 10 SCC, 2013, 10 SCC, 237. Your lordship first comes to paragraph 16. My lords, relying on Pradeep Jain, if your lordship sees Justice Padiwala has that?
Yes.
I'm grateful. We now come to clauses 2 and 3 of the eligibility criteria in the information bulletin. Under clauses 2 and 3, a domicile of Uttarakhand who has passed MBBS from a medical college of some other state, having been admitted either through 15% All India quota or through the pre-medical test conducted by the state government concerned, has been made eligible for admission to a postgraduate medical course in the state quota. Obviously, a candidate who is not a domicile of Uttarakhand is not eligible for admission to the postgraduate course under clauses 2 and 3 of the eligibility criteria. Preference, therefore, is given only on the basis of residence or domicile in the state of Uttarakhand under clauses 2 and 3 of the eligibility criteria. And such preference on the basis of residence or domicile within a state has been held to be violative of...
Now that you are challenging 8.2 of the state's rule, why have you come here directly?
My lords, because of the time constraint. Now just see paragraph 19.
Well,
now paragraph 19 deals with this clause.
What?
This,
High Court.
well, paragraph 19 deals with an idea.
Why should we invent it? These are essentially individual students coming here under 32 challenging a state.
Because of the time constraints, my lords. Now the admission process will start. Just see paragraph 19. Well, just for a moment, your lordship sees paragraph.
Mr. Ahmed, you go to the Bombay High Court. The Bombay High Court can well deal with this.
Well, let me read 4 lines of paragraph.
Why should we entertain a petition like this?
Here also, your lordship.
Otherwise, we will be. You can always go to the High Court and get this relief.
Here also, your lordships have entertained it under 32. This very judgment. Please see paragraph 19. Just for a moment. Just for a moment. Paragraph 19. It will thus be clear from what has been held by a 3-judge bench of this court in Megan Mehrotra that no preference can be given to candidates on the basis of domicile to complete the institutional quota of the
Let
state.
the High Court consider.
If such candidates have done their MBBS course,
Let the High Court, the petitioner has an efficacious remedy of moving the High Court of Judicature at Bombay, the exercise of the jurisdiction and Article 226 of the Constitution. Stop. Since the challenge is to clauses 8.2 and 8.3 of the, what is it called? Admission Bulletin?
Of the
NEET-PG 2024.
Yes.
Information bulletin issued by the state of Maharashtra. It is but appropriate that such a challenge is addressed before the High Court of Judicature at Bombay. So we therefore dispose of the petition under Article 32, leaving it open to the petitioner to pursue the remedy available.
Well, if I move the High Court with him,
The event is that the
because since the
petitioner
admission
does
process
so,
will start.
we would request the High Court to take it up with all due respect.
Lodge. I'm grateful.
24.
My apologies. I appear for the petitioner in item 24. On Saturday, my lords, I have been served with an affidavit in reply, the counter by the other side. May I seek accommodation of 2 weeks to file my rejoinder? They are challenging maintainability of my petition. I'll have to answer that, my lords, in rejoinder. My lords. Oblige, lords.
25.
Grateful.
I appear for the petitioner.
Who is appearing for the respondent?
Lord, I appear for the respondent.
Are you agreeable to an arbitration?
Yes, Lord. Lord, the only thing is, Lord, that it has to be in a neutral, non-biased location. So in the context of international commercial arbitration, we have already replied. We have said that it can't be India, it can't be USA, it has to be some other country.
Why? We can appoint. You both agree to, and what does the arbitration agreement say? In a neutral, non-biased location.
Exactly. Article 9, page 27.
Lordship, it does not talk about a country, it talks about a location. And if permitted, let me file a rejoinder to the reply.
No, but we'll appoint an arbitrator. Why don't you both agree to the appointment of an arbitrator of your choice? If you can both agree to one arbitrator, a sole arbitrator, we can appoint you. Once you have faith in the arbitrator, then it shouldn't be really a problem as such.
Very well. Can we, then, my lord, since a reply is filed, if we can sit together and find out possibility to explore this. Otherwise, if your lordships have, page,
we'll discuss with them.
If your lordships have page 51, we have suggested that even single.
How much is the claim?
It's almost
2 crores 34 lakhs.
2 crores.
2 crores and 34 lakhs. Why don't you both tell us the name of an arbitrator? If you have both some faith in a lawyer, we can appoint a lawyer. It's not a very large claim, 2 crores and 34 lakhs.
My lords, we don't mind if, very well, we don't mind if it's done in Ahmedabad, actually. Any honorable retired judge of the High Court, Gujarat High Court.
Mehta, what is this non-biased location?
Yes, my lord. Article 9, if your lordships have, on page 27, it mentions in a neutral, non-biased location.
Then Ahmedabad is a non-biased location.
Yes, my lord. Because yes, Ahmedabad is a non-biased location. Yes. Because, my lord,
So we'll appoint we'll say that they have no objection to the appointment of an arbitrator. We'll appoint Justice Akhil Qureshi as a sole arbitrator.
Oh, my lord, even can we suggest names from the Gujarat High Court, my lord, retired judges of the Gujarat High Court? We can give 2 or 3 couple of.
Qureshi was a judge of the Gujarat High Court.
Correct. That's true. Or even Justice. Very well. Or even Justice MD Shah, Justice Soni, there are. I mean, we have more than 2 names.
The respondents have no objection. The parties have no objection to the appointment of a sole arbitrator. It's sentence ka lijiye. Usual order aayega. Hence, Justice Akhil Qureshi, former judge of the High Court of Judicature and of the High Court of Judicature at Bombay, is appointed as a sole arbitrator. But Chief Justice of the High Court of Rajasthan is
Very well.
May I please, my lords? It's a dispute between partners
And Lords, I'm a citizen. Yes, my lords. Lords, it's a dispute between partners. I'm for the petitioners, my lords. Petition number 1 is the resident of Oman, my lords. That's why we are before my lords.
Services complete?
Yes, my lords. As per the office report, my lords, updated today. It's
What does the arbitration clause provide?
it's on page 33. It says that the arbitration proceedings shall be conducted at New Delhi. Page 33 of the
How much is the claim?
My lords, the claim should not cross 3 crores, my lords.
Not cross 3 crores. Asha Menon, former judge of the Delhi High Court, and it will be under the auspices of the Delhi International Arbitration Center.
So very grateful, my lords. So very grateful.
27.
Obliged. TPL.
Who's appearing?
This is the first appearance for respondent. My lord, our reply has been already sent to respondent for their inputs. Lord, may roll it over for a week.
Already take it on the Monday after we reopen.
Very well. So great.
Bombay High Court constituted the tribunal. You are for the petitioner.
My lords, I'm appearing for the petitioner. My lord had already considered this matter on Thursday and only to await the reply which has been kept on Monday.
My lords, we have filed the counter. My lords, the dispute is also the subject matter. Now here.
So the tribunal now consists of 3 persons, Mr. Sharma, Mr. Kemkar, and then Mr. Justice Patil.
My lords can appoint a sole arbitrator. This is only about 8 odd crores.
How much is it?
About
Which is
800
seat of, what is the seat of the arbitration?
Bombay.
Seat of arbitration is Bombay.
My lords, my concern is also, my lords, the subject matter. Here the goods were seized by the government, my lords. As far as we are concerned, we already supplied.
All that, of course, can be decided by the
tribunal. That will be, of course, dealt with by the arbitrator.
That's on merit.
My lords, but the problem is, my lords, as far as my liability is concerned, this is on record that we have supplied the goods to their forwarding agent. That forwarding agent, the goods were seized by virtue of the notification of the government, my lords. All the goods were subsequently used by the government, my lords. Those all masks and everything. So essentially, there are orders, my lords, we have already placed.
Why don't we do this? That if you are both agreeable, Justice Naresh Patil has been appointed as a presiding arbitrator.
Very well. Very
we can appoint him as a sole arbitrator. That will be much easier.
My lords, in fact, we have paid the fees also to the Honorable Tribunal.
Well, I think some ad hoc amount has been paid which was only in respect of one particular hearing and as the order would reflect. In fact, the tribunal from the very first.
So why don't you then go to all the 3? What is the problem?
We can go to all the 3, no difficulty.
My lords, we would request if sole arbitrator.
All right. Learned counsel on behalf, appearing on behalf of both the usual order of both the, ऐसा लिख लीजिए, by an order dated 25 April 2024, the High Court of Judicature at Bombay, in a proceeding under section 11(6) of the Arbitration and Conciliation Act, appointed the nominee arbitrator of the respondent, correct?
Correct. Justice Shantanu came.
The petitioner had already nominated its arbitrator. Full stop. Thereafter, on 16 May 2024, the 2 arbitrators appointed Justice Naresh Patil, former Chief Justice of the High Court of Judicature at Bombay, as the presiding arbitrator, as the 3rd arbitrator. Full stop. The petitioner has now contended that the application before the High Court of Judicature at Bombay was based on incorrect legal advice, since the dispute is an international commercial arbitration. Full stop. The petitioner, full stop. The fact that the dispute arises out of an international commercial arbitration is not in dispute. Full stop. Next. Both the learned counsel are agreed that a sole arbitrator may be appointed, having regard to the nature and quantum of the claim and in the interests of expedition.
Obliged.
Stop. Accordingly, they have agreed that Mr. Justice Naresh Patil, former Chief Justice of the High Court of Judicature at Bombay, shall stand appointed as the sole arbitrator under the Arbitration and Conciliation Act 1996.
And maybe my lords can consider these being administered through MCI, since this is Bombay.
The arbitration proceedings shall be administered through the Mumbai Center for International Arbitration.
And the fee shall be governed by the rules.
And the fees shall be governed by the rules of MCI.
Obliged.
Stop. Payments already made to the two other arbitrators shall, however, not be recovered by the parties. It has been agreed, of course. Small detail. 29.
Obliged.
29, I'm appearing for the state of Madhya Pradesh. There is some further investigation going on, some documents on which I want to rely. Therefore, my lords may give me some time, for 4 weeks' time. He is protected, the trial is stayed.
Well, the application for vacation of stay has to go, Malad, because the FIR has been quashed by the High Court.
FIR has been quashed by the High Court.
That's the subsequent, that's a different FIR.
No, that is the one that for which you filed the application. Don't say that. You
Let
asked.
let it be on the next statement.
No, but the FIR has been quashed. Where is the question of the application surviving? Malad, and see what,
Application has
just
gone,
have a
that's
look.
what I'm told.
Have a look at page 29, what they are doing, Malad. Adoption in 2009. Sorry,
It is
Malad.
said as far as adoption is concerned.
Malad, kindly see, adoption in 2016-17, offer in 2009, challenged in 2024, 6th August.
Raju wants a little time.
But Malad, why should this application be there? It's FIR is
Application by them for vacating the stay.
That's right.
That we are not entertaining it today.
Quashed by the High Court, Malad.
We are not vacating the application for we are not vacating
May
the
I
stay.
give me a minute?
But Mr. Raju says he wants to put some material on the record. We'll take it on the reopening immediately after.
Yeah, give me a minute, Malad. Just kindly come to page 29.
I don't see.
What?
why
Hold
not.
on, allow me.
Trial has been stayed. Nothing is happening.
Mr. Sibal will give him one opportunity to.
I don't mind, Malad, but just have a look at page.
No, but they're registering fresh FIRs, Malad. This is the malified intent. When the matter is pending here, why keep registering fresh FIRs? In this last one,
20
the High Court has
policemen.
found it to be malified.
20 policemen come, then they break open the house, Malad. Just see what they are doing. Just see the photographs. Break open the home.
Washed actually.
The FIR lodged in August 6th.
It is not the subject matter of this.
No.
Today you have come against the order of framing charges, right?
No, and therefore they're asking for vacation of this stay based on that
Based on
FIR.
that FIR.
We are not vacating the stay.
Very well.
But we are not vacating the
What is
stay at all.
happening is they continuously harassing us. This is the whole problem.
No, who is harassing
break
whom
open
and
the
who is
home,
not harassing
Malad.
whom is a matter of fact. I'll point out, Malad.
Anyway, let
That's
him.
what we'll do is we'll take it after the reopening, after the 1 week. On
Very
Monday, we'll take it up. Whatever he wants to file, let him file.
Very
Very good, very good.
Great for this.
Not for
Not giving it a fixed date, Malad. Week,
Yes, right on that Monday.
week starting on the 11th, Malad.
Yes.
Great.
No, 1 week after.
Third, Gaurav.
11th.
Third, they want it on the 3rd. We'll take it up immediately after the reopening.
10th, Malad. First week.
That's fine.
3rd, we'll take it up on the 3rd.
This Sunday.
Third, I have some problem.
Take it up on the 4th, 5th, no problem.
The contract was concluded in 1991. The MSME came into
8 days. Why should we-
Lord, this problem was, Lord, The judgment, my lord, was not pronounced in the open court. By the time it was announced, my lord, we could not.
Delay will not condone this.
My lord, Lordship may issue notice on that, my lord, and Lordship.
Will not condone the delay.
My lord, the only problem is here.
News to their benefit.
My lord, the only problem here is, my lord, that, my lord, it's clearly covered. My lord, 91 is, my lord, is the contract.
You have
Date
to
of the
open the
contract.
door, Rajat. There's a delay on your part.
My lord, 91 is, my lord, the contract. My lord, this is the government company. It's a sick company.
The impugned order says you have to challenge it by following the procedure under section 34.
But challenge that says deposit 75%.
You have to
2
deposit.
lakhs is the amount. 2 lakhs is the amount.
You have to deposit it.
It's 7 crores now.
But
kindly say 2 lakhs is the amount. Where will the government pay from? The STC is a very sick company.
I know.
But your lordship will not consider one thing. But I will.
The delay of 128 days.
Lordship will consider one. Lordship will consider. Lordship will consider one thing. The matter is coming up on the 21st. It's not covered, but it's a nullity. What is a nullity? May not admittedly a nullity.
We are not condoning the delay. You can't argue on merits to condone the delay.
Lordship, Lordship will not give me some time, extension of time for before the 21st is the date, my lord. For deposit, my lord. I can't do it Monday, my lord. Monday I can't do it, my lord. Lordship will give 1 month.
Time for deposit.
Deposit, my lord.
Extended by a period of
6 weeks, my lord. 6 weeks.
By a period of 4 weeks.
6 weeks. And my lord, installments, 2 installments.
We've given you 4 weeks, yes.
My lord, the year has outlived its life. It was extension till today. But I'm told, my lord, the report is ready. If your lordships can consider extending for 2 weeks, Lord, it would be published.
All right. The Mr. Tushar Mehta, Learned Solicitor General, submits that the report of the high-level committee of experts is ready and would be filed within a period of 2 weeks. Yes. Time is extended for that purpose till 2 weeks ka time.
Correct. Grateful.
The High Court errs on 2 counts. Firstly, my lord, so far as the applicability of the model rules vis-a-vis the MP rules are concerned, my lord, Section 24 says, my lord, that the central government will only frame model rules, which will, my lord, be...
They say that because they had made an application for renewal of the license, therefore the deeming provision
under the central model
rules will apply.
Now, both counts, my lord, in my respectful submission, the High Court errs. Firstly, the model rules will not apply when the state has already framed rules under Section 25 of the Act. My lord, the model rules are only a model to be followed by the state government. The state government has in fact framed rules which does not contain a deeming fiction at all.
There's no deeming.
There's no deeming fiction.
So on that day, they didn't have the license.
They didn't have the license. Even otherwise, my lord, that the period is 45 days. They applied within 43 days. So consequently, even then, my lord, the deeming fiction under the central rules does not apply.
Sorry, what is that point?
My lord, the deeming fiction applies provided they have complied with the statute and have applied within a period of 45 days of expiry of the license. They did not do that. They applied 43 days prior to that. So consequently, my lord, in law, the deeming fiction will not apply.
My lords, for the petitioner, original petitioner, respondent number 7 here, my lords.
Under the state rules, there's no deeming fiction.
My lords, actually, that was not the ground on which my technical bid was rejected.
No, but the point is,
my lords,
ultimately the High Court holds in your favor and says your bid should be also considered.
Yes, my lords.
On the ground that under the deeming fiction, under the central rules, you will get the benefit, and therefore, once you had applied, your license is deemed to be renewed. Is there a deeming provision under the state?
No, my lords. That factor has been considered by the court, my lords.
But if there's, that means you didn't have a license at that point.
If the plain reading is done, my lords, that would be true. But then, my lords, the rejection, that the technical bid was rejected on the ground that you did not apply within that 45 days, my lords, under the model. So once they apply the model rules and say that you've not applied the 45 days.
Fact remains you didn't have a license, right?
But then they applied the model rules, my lords. And they can't pick and choose, my lords. Para 23, this aspect has been considered, my lord.
Issue notice here. You file your return, and we'll stay the operation of the order of the High Court till the next date of listing.
Please.
Notice returnable on click day. Pending further orders, the stay of the tax. 34.
Sorry. Well, in a review petition, the appointment of the learned arbitrator is recalled. Kindly see page 469. The first day when the parties appeared, there was a recording, specific recording by the learned arbitrator, page 469, my lords. May I just read 4 lines?
Yes.
Both the parties as well as their counsel stated that they have no objection towards my appointment as the sole arbitrator of the arbitral tribunal to act as an arbitrator as ordered by the Honorable Patna High Court by order dated 1/2/23. After the specific stand taken before the learned arbitrator and after that filing a counterclaim, and now today the stage is the claimant's witness is complete in terms of cross-examination. It's an advanced stage of evidence. I'm so grateful. There's one submission. Now, it so happened that I had a bank guarantee of 15 crores. I had on the first day a stay on the bank guarantee encashment. 4th October, the order is issued by the Honorable High Court. I informed them on 6th that I have a bank guarantee, but then also I'm moving this Honorable Court. 9th, I moved. The moment I moved, within a few hours, they encashed the bank guarantee, my lords.
Now the money is gone, right?
But my lords, the problem is I'm in deep trouble. I have a 20 crore bank loan, my lords.
So what we'll do is we'll issue notice and keep it right on the Monday after we reopen. You serve them, dusty and come.
I'm so grateful. I also.
And perhaps on the bank guarantee, if we restore your arbitration,
My lord.
set aside this order of the High Court in review, you may have to apply before the arbitral tribunal for bringing that money before the tribunal.
My lords, for your lord,
something like that.
Understand, my lords, but I
That will be in a section. That be in a section 17.
But in fact, if my lords is restoring the arbitration, then in my submission, the interim order granted by the arbitrator
that
ought to be restored again. In which situation your lordship would consider? I moved an application already before your lordship.
Right after hearing them, but we'll issue notice in this.
But may I also be
on the Monday
serve,
after.
may also be permitted to serve the standing counsel because
And
it's a state.
Liberty to serve the standing counsel for the state of Bihar in addition.
Highly grateful.
As I appear for a miracle.
One more thing, Mr. Devash, how did the High Court review its order under 11.6? There's an order under 11.6, right?
11.6, my lords.
Where was the review?
And that too with a delay of 127 days, but even that,
anyway,
whether they would have the power, I'm so
Just
grateful.
consider that.
I would, my lords. I'm grateful.
Wait, please. Appear, my lords, in 35 for a medical candidate, my lords, who would have applied in the NEET successfully.
The only thing is, look, her mother is engaged with the Nuclear Power Corporation of India. She is posted in Karnataka.
That's right.
Grandfather is from Karnataka. Father is employed with the electricity department in Karnataka.
In Goa.
In Goa.
Sorry, not Goa. Not
addition,
in
in her
Karnataka,
favor.
in Goa.
Correct.
We are dealing with Goa here.
Correct, that's right.
Now, technically, I mean, the High Court has taken a broad view, saying that there is an exception, right? There's an exception clause.
I'll just take your lordships through that. Now,
That
what is,
says
I am not asking for
you're
an
a child of government servant.
Correct. So I'll just point out, I am not asking at the outset. At the outset, I am not even asking for annulment of her admission. That is the first thing your lordship should take.
And she is not an imposter.
No, it's not. It's
Because
not. I'm not
her
claiming.
father, even today,
Correct.
Serves.
Continues to serve.
service in Goa.
And in addition to that, in her favor,
High
her
Court says she went to Karnataka for the reason that the mother was based in Karnataka. Mother was employed at the Nuclear Power Corporation. Therefore, she did her 12th standard from Karnataka.
Correct. Your lordships have obviously seen it.
Why displace a
your
young
lordship
girl
said that.
from getting medical admission?
I'll start submitting on that. Now, my lords, my first very important substantial submission is this. I am not seeking the annulment of her admission. That's point number 1.
That's not possible. I'm not
even
we cancel her admission.
Will not
only
get
then
it.
you
I
get
am even asking for that. I am coming up with a via media, a suggestion, which is there in the prospectus. Your lordships don't even have to go beyond the prospectus.
What is that?
Now, please have page 96 for a moment. The prospectus, my lord, starts at page 72.
I am referring to page 96, 97, and 98, where the categories are laid down. Now, the ineligibility of the respondent number 7, the admitted candidate, comes from paragraph 5.1. I am not going to rely on that.
Then should you not assert your own right to seek admission rather than challenging the admission of
Your Lordship will see, that's my second submission. 2 writ petitions have been filed before the High Court. One,
if you are otherwise entitled to seek admission as of right under the rules, why do you need to challenge the admission even to this girl?
I have applied through a writ petition. My writ petition is tagged with her writ petition. Merits of her writ petition are decided. Not a single submission of my writ petition has been adjudicated
You
upon.
you can't gain admission unless she is displaced.
No, kindly see that's
the problem. So now seats are all filled up.
No, please appreciate. Please have
seats will be all filled up. Therefore, you rightly challenge your client is justified. You challenged her admission on the ground that if she goes out, you are higher in merit and therefore you would be entitled to it.
I'll point out she's higher in merit. She is. This is for the last seat.
And he is 45.
This is for the last seat. There are 44 seats. Please see 98.
If she is taken out of the fray, then the seat will go to
I am not asking for that. Please appreciate.
But how will you get an admission?
Well, please see 98. The answer is right there. See 98.
What is that?
There is a different category under which she could be adjusted. Serial number 5.7. There is a reservation for 3% seats for central government, state government, and PSU employees. Their wards, please see 98 for a moment.
It's already filled out.
No, I am coming to the other one if my learned friend will allow me. Please see.
We'll not leave her in the lurch to be.
I am not asking,
just against some other category.
At the outset, Malots, I started by saying it. Third time I'm repeating with the greatest humility, Malots. I am not asking for her displacement. Take it from me. Please see 5.7, 5.9, and 5.1. 10. Please see that, please, with the greatest respect. 5.7 Malots is 3% Malots is reservation for central government, state government, and PSU employees. There is another category where if it is merely a case of adjustment of the candidate, it is nobody's.
She has not applied in that category.
No, therefore, I am asking.
We have so many candidates who come here and tell us, please adjust my category, and we reject their petition.
We are referring to a candidate.
It's a correct judgment of the High Court.
May I just point out? Please see, your lordships have always.
Therefore, the facts are very, very stark and telling.
May I make this?
She is not a person who is an imposter.
Lordships are right.
Father employed in Goa, grandfather, mother, she went to Karnataka because, I mean, you can understand. The girl child wanted to be with the mother. And mother also what? Mother is not in some private sector organization. She is working for the Nuclear Power Corporation of India Limited.
I'm just showing the way forward. If your lordships will bear with me for 2 minutes. I'm not asking for that. Please.
We leave it. Thank you.
As your lordship.
Obliged.
My candidate is greater in age, number 1. Number 2 also belongs to the OBC category. I'm asking for some leeway in this. There is a way forward. I was wanting to show that to your lordship. As your lordship, please. Grateful, Lordship.
36.
I have a preliminary objection.
Lordship,
36 fellows. Can I have a
Lordship,
objection?
I'm the petitioner. May I just make my submission?
I have a preliminary objection.
Can
I make it?
Lordship, I think
You're
it's
not
petitioner.
I will not argue the matter.
You're not arguing merits in the guise of a preliminary
That
objection.
is far too difficult to camouflage it before lordships.
All right, tell us what is a preliminary objection.
The same, the office report says this. The same impugned order as in today's case came before a bench headed by my Lord Justice Darsema. He heard at some length, issued notice and fixed on 4th of November. That's preliminary objection number 1. So, it's surprising and no stay granted after we both appeared. Number 2. My learned friends have challenged the same order here without challenging the subsequent order by which they are really aggrieved, 7th of October. 7th October,
May I just make a submission? Yes, your lordship.
This order is the subject matter of a challenge for justice.
Yes, I was going to point that out. I don't know why they preempted making we are doing something which is wrong.
We'll do is this. We'll place it before justice.
But tomorrow, your lordship, may I make a submission?
Friday before justice.
Lordship, it will be too late. It will be too late. May I just please make a submission?
Already tomorrow.
Tomorrow, it can be before Justice Darsema. No problem. It can be listed tomorrow.
Fair enough.
Obliged.
I'm obliged.
There are 2 obliged.
List before a bench.
There are 2 other matters also today.
List before a bench. What is the matter which was
the first
that is
office report,
path, right?
The first, yes.
Appeal 406004.
That is diary, I think.
No, this is, yes.
The diary number 40604 of 2024, arising out of the same order of arising out of the same impugned order of Aptel dated 22 August 2024.
Yes.
Was listed on 23 September 2024 before a bench presided over by Honorable Mr. Justice P.S. Narasimha. First off, the registry shall accordingly list the present proceedings before a bench presided over by Justice P.S. Narasimha. Preferably tomorrow after seeking.
Because we have a disconnection notice which we have got after. What has happened in there, we have got disconnection notice. We just requested to be tomorrow.
Tomorrow we'll keep it tomorrow, no problem.
I'm grateful, most grateful, Your Lordships.
Can I have that?
Even the connected matters, Your Lordships.
They're coming up. Which are the connected matters?
There are some new more matters.
You mentioned before Justice Narasimha.
There in those.
Or circulate an email. I'll pass order on that.
I'll do that.
Those matters.
Lordship, there is one page I need to
All
replace.
right, fair enough. Just circulate an email.
I'll do that. Lordship,
That listing is my prerogative. I'll place it before
Lordship,
Justice.
kindly consider one page need be replaced. Wrongly, it has gone. Lordship gives me leave. I'll do that today, right away.
Now, if we are keeping it tomorrow before Justice Narasimha, just tender that one page and get an order from him.
All right.
I'm grateful, Your Lordships.
Yes, item 37.
Yes, Malaj, I appear in this. Malaj, can I just hand over Malaj a little note to your lordship?
Yes. Sibyl, can we just take a little
We are on KV.
break for 10
Yes,
minutes
yes,
and
yes,
come back?
yes, no issue.
Just for 2 minutes, we'll take a break.
No problem at all.
In case somewhere else, any of you can pass it over and then take it later in case you're called out somewhere else, either of you.
Obliged.
the state and the public.
Yes. So Sibyl is.
Because he was here.
All right, we'll just roll it. We'll
Can I-
pick it up the moment he is here.
Very well, sir.
38.
Your Lordship, I request for a password in this matter.
Why have you come under 220, 32 over here?
Your Lordship, the senior who I'm briefing is on his.
Your writ petition was dismissed by the Delhi High Court for lack of territorial jurisdiction.
Yes, Your Lordship.
Why? And you now file a 32 petition here.
Your
You
Lord-
file a petition before the competent High Court.
Your Lordship, the only grievances that counseling are going on, and this court has intervened in a lot of cases.
Delhi High Court, right?
Yes, Your Lordship.
You went to a High Court.
Your Lordship.
Now you must go to the
file a
correct High Court.
Your Lordship, may pass over the matter this.
Petitioner would be at liberty to move a petition
Your
under
Lordship,
Article 226 of the Constitution before the jurisdictional High Court.
Your Lordship, just understand the grievance that council.
We have understood it, we've read it. Thank you.
The High
Thank you.
Supreme Court has fixed the.
39.
So Ranjit Kumar is on his legs. May I seek a password?
Tag with that NHAI versus State Bank of India?
Separate. My lord, there's a separate issue in this.
Can I say this, my lord? The dispute is only between NHA and us. And we have, your lordship has guided us. We have now trying to sort it out. We have taken time. Their grievances, this board alone can decide how much amount should be dispersed as per the earlier order of NCLAT. And how could they intercede to it? And through an order. The NCLAT records are finding in para 11 to 13. We have given you ample time and opportunity for the board to resolve it. And what is there between me and NHA? We are sorting it out.
We'll hear Ms. Ranjit Kumar in a moment. There's something to be argued
Yes.
by. Item 40. Who is for the petitioner?
R1.
R1.
May I appear for R2?
Yes.
This is a factual position. It was a suit for specific performance on which limitation was one question. It is a question of fact and law. That is one. I also want to tell you, Lordship.
Last time their submission wasn't fair. We don't know. They've been filing.
Regardless of the question, my lord, whether the amendment to section 10 of the Specific Relief Act, which takes away the discretion, regardless of that, my lord, it's based on the facts, the entire suit.
So what are you going to argue?
So, my lord, what we are going to argue is that the basis of saying that time is the essence of the contract, because ultimately it is the application of Article 54 of the Limitation Act. Is it from the date the cause of action arose or from the date of refusal? Our case is it is 3 years from the date of refusal when the legal notice was given and you replied to it denying your obligations under the contract. Their case is that the original agreement from that date, if you take 3 years, the suit is barred by limitation. Now, the complete fundamental error in the order under or the judgment under review is they pick up an agreement which is not between the parties. Earlier, what had happened in the matter was the original owners had sold to them and they sold to us. So our agreement is of 1997. Their agreement with the original owners is of 94. So they pick up that agreement, one. Secondly, they relied on clause 21 of the second agreement between us and them, which effectively only said one limited issue. And what it said was that all that this agreement that we are concerned with is that the payment that we are making to you, the payments made to those original owners are of no consequence any longer because we have already paid them. That is them, they have already paid them, the original owners. This is all that clause 21 of our 97 agreement said. The judgment under review goes on to say on its own that the agreement to sell was dated 1994. In 1997, as per clause 21, which is the clause in question, you were given the last opportunity to make the payment. And because this was the last opportunity, time is the essence and thus the suit is barred. Now, my lords, two fundamental and grave errors. Firstly, 94 is not the agreement between us. The first agreement between us is 97. There's a clear misconception.
Not with great respect.
This is like a first appeal.
The first agreement or the second agreement is out of time. My friend is now re-arguing the matter.
Sorry.
And you look at this clause, without error.
I have to open my case.
It cannot be an error without a parent.
And let us put in a reply, my lord. Let us put in a reply. They took 6 weeks for additional documents.
in which case we dismiss the review. Can you just show us where have they relied upon the 94 agreement, which was not between you inter partes?
Yes.
Let us see that.
Please first have para 32. Just a minute. Para 32. And there are many other paras. I'm just showing one para because this covers both clause 21 and the 94 agreement. My lords, has para 32 on page 22.
Just a second.
You can show me the clause.
Para 32.
Yes. Coming to the aforesaid indicators, the language of the agreements make it clear that severe consequences of the judgment. No, this is on PDF 42, if your lordship wants that.
PDF page 29 actually. Para 32, right? Coming to the aforesaid indicators. This is
My lords have para 32?
Yes.
Coming to the aforesaid indicators, the language of the agreement makes it clear that severe consequences of forfeiture would ensue if the payment. Did not matter. Take the correct case. Yes, my lords, have para 32?
Yes.
Coming to the aforesaid indicators, the language of the agreements make it clear that severe consequences of forfeiture would ensue if the payment is not made within 3 months of the date of agreements. It may be noted that as per clause 21, the parties had entered into an earlier agreement to sell dated 19/3/94, which did not materialize, and accordingly the agreed price therein is no longer applicable. It is in this context that the fresh agreement was entered into between the parties so as to provide a last opportunity for them to successfully enter into a sale purchase agreement. The aforesaid intention of the parties is made clear through clause 23 of the agreement to sell, which reads as under: the parties of the second part herein undertake on any pretext that they will not make any claim for enhancing the agreed sale consideration. Now please have clause 21 of the 97 agreement. So two fundamental errors. 94 is not between us. 94 is between the original owners and the people who have sold to us, the vendors, in this matter. And please see clause 21. The most important thing, please see clause 21 on page 118 of the SLP. Page 118.
Page 118. That is an annexure. Oh, it will not be in the review. It will not be in the review. No?
It's in the SLP, my lords, annexure P1 starting at page 109 at 118.
Agreement to sell.
Please, my lords.
Annexure P1, right?
Yes, my lords. Annexure P1 at 109. Please have 118 at clause 21.
It will be
at 118. the parties of the first part are not at all concerned to the sale consideration agreed by the parties of the second part herein with the purchaser, as already they received the agreed sale consideration from the parties of the second part herein as per agreement dated 19th May 94. Where does it say this is the last opportunity? This is the second agreement after 94. 94 was between them and the original owners. So the purpose of clause 21 was if the original owners have all and who are described as first party, because you've received money, so you can't take further money from the purchaser herein. And this is between me and them who are referred to as the second party in the agreement to sale. And we are the purchasers.
Party of the first part is them.
Is the original owner.
Oh, the parties of the first part is the original
owner. He is not concerned now. That is the purpose of clause 21. Now, please see the import of what that para I read out to say. 94, there was the first agreement. Then you could not pay in 94. So 97, the second agreement was entered into. And the 97 agreement, clause 21 said is the last opportunity. Now, firstly, my lords, 94, there is no agreement between us. 97, just a minute. 97 is our first agreement. Clause 21 nowhere talks about a last opportunity. My lords, in any number of judgment your lordships have held that if a judgment is based on clear misconception on facts and law, that is a ground for review under order 41. This is a case because from that flows the consequential conclusion, that is, because the agreement was entered into 94, last opportunity was given in 97, time is the essence, and from the date of the original agreement, your suit is time barred. Our case is that after 97 agreement, we kept writing to you. We finally gave you a legal notice in 2000. You refused complying with it, and in 2002, we filed the suit. So time as per Article 54 of the Limitation Act, in our case, since time is not the essence, will start from the date of refusal, not from the date of original cause of action. And please keep in mind that 90% of the consideration in this matter was paid within the 3 months. Before 3 months as the original agreement in 1997 provided. The balance 10% was not paid because they had to comply with a lot of income tax clearances and documents they had to give us. That's part of the ULC etc., which is part of the agreement. So that 10% was not paid. Now, if you thought that the agreement had come to an end, you could have sent me a notice terminating it. You could have returned the 90%. Because the clause only provided that if you don't comply in 30 days, then the earnest money will be forfeited. The clause did not say 90% will be forfeited. So clearly the High Court came to the conclusion in the matter that time is the essence of the matter. And if time is the essence, time is not the essence in the contract, and if time is not the essence in the contract, then we will see it from the date of refusal. Be that as it may, my lord, that's something.
Our court really holds the 94 agreement shows that what.
No. The High Court does not. 94 is between them and the original owner. High Court simply says.
No, our court, I said.
Please, my lord, your lordships in this clause are saying, in this clause in 32 are saying, that the first agreement is on 94. This was the last opportunity to pay after that because clause 21 of the 97 agreement says last opportunity. Why does it say last opportunity? Because according to the court, the Supreme Court, the first agreement was in 1994. And since you did not comply with it, the 1997 agreement was entered into with clause 21 as the last opportunity. Please have 32 again for a minute, my lord.
Yes, we saw
yes. May I just read it again, my lord?
So we saw
yes. So the whole logic of this last opportunity is that there was 94, there is 97, clause 21 of the 97 agreement provided the last opportunity. You still did not comply with it. Thus, time is the essence. Now that becomes the principal basis. And most interesting.
94 is not inter partes anyway.
Yes. And then, my lord, with great respect, then secondly comes legal notice. Now the legal notice sent by me clearly says that you right from 97 have not complied with what you are required to comply. In fact,
This is of the 1997 agreement.
Yes. And that was absolutely. Now, please have one more paragraph 5, which I'm grateful to my learned friend for pointing out. Please have
Paragraph
5. Para 5 on page 3.
Of the judgment?
Yes.
Yes, of the judgment.
Judgment of which
Yes.
review is sought.
The agreement dated, my Lord the Chief Justice. Yes. Agreement dated 19/3/94 and registered GPA in favor of respondent purchaser could not materialize. This is not with me. I have no 94 agreement with them. Parties entered into fresh agreements dated 26/3/97 and 27/3/97 herein to purchase an extent of so much. So the same error continues, culminating in 32. And then, my lords, the other ground to hold that time is the essence is, I give a legal notice. And the legal notice clearly says, from 97, I have repeatedly come to you. I've paid 90% within the first 2 months of the agreement being entered into. It's only 10%, and I did not pay it because you did not give the balance consideration. You've not repudiated, you've not terminated, you've not returned. You've not forfeited. You could only forfeit the earnest money. Now, and you started negotiating with other parties, and because nothing materialized with them, you again came back to me, and now the legal notice is being issued. The Supreme Court says that, look, in your legal notice, you said that they were negotiating with other parties, and because that did not materialize, they came back to you. Thus, time is the essence. Now, my lord, whether they were negotiating, not negotiating with other parties, how does it make time the essence? I want to show the legal notice to your lordships, and what is the conclusion? Time of the essence is based on 2 principal grounds. 94 agreement, 97 is the last opportunity, and because 97 is the last opportunity, thus time is the essence, and thus the suit is barred. Secondly, time is the essence because your legal notice on its own said that they were negotiating with other parties, and because that did not fructify, they came to you. How does that make time the essence? I don't know, but I want to show that legal notice, and I want to show the conclusion drawn that how could the Supreme Court ever have drawn a conclusion that time is the essence based on this legal notice and the interpretation that it is seeking to give to it. No legal or factual basis at all for this conclusion drawn. Please have, no, just a minute, let me complete. Please now have the legal notice.
So 10% is deposited.
I just want to read this legal notice out. It's important for your lordships to see. I deposited the balance 10% also when the suit was filed. The court directed me. I deposited my 10% then. There and then, although they had not complied with their requirements of documentary compliances, that order of the court was not appealed against, or depositing the balance 10% in the suit proceedings. Now, please have my legal notice, just 2 paragraphs and 1 para of the order under review. How could that conclusion have been raised by the Supreme Court? Please have para 2 on page 136.
Of the legal notice?
Of the SLP?
Yes.
Of the SLP, annexure P3, my lords.
Is the legal notice dated 8/2/2000.
Yes.
The due amounts pursuant to the due date as among mentioned agreement of sale dated 26/3/97 and 27/3/97 were attached with rider that due persons would be under an obligation to furnish all relevant statutory clearances, documents to my clients, but at the time of payment of the balance sale consideration within the said period by my clients to you person, you have deliberately refused to receive the same on one pretext or the other as the reasons best known to you, which were never disclosed to my clients. This aspect of common conduct lies exhibited by you persons is nothing but dilatory with an oblique motive, which our clients resent, and further an objective motive, which our clients resents, and further so and so. Then para 3. However, the due efforts by my clients proved little hope when you have strongly urged my clients to come up with balance of sale consideration in view of the fact that other interested parties are not available at the moment, end of Jan 2000, and thereafter you have promised to complete the transaction by executing the sale deed in favor of my clients. On 8/1/2000, my clients have bought the balance sale consideration to you and requested you to make arrangements for execution of the sale deed on convenient date in client's favor, but you have refused to accept the same as the situation prevailing was incompatible. This aspect was not convincing to my client. However, they have expressed by their acts, by showing their willingness for the performance of the said agreement or sale mentioned above, adhering to the said conditions. The conduct related by my clients for the performance of the said agreement is their willingness at all times and also non-adherence to the said terms and conditions of the completion of transaction, either for specific performance of the agreement or for return of the part of the substantial sale consideration is lapse on your part, for which our client was suffered and is suffering. Now again, our clients through this notice express their willingness to complete the sale transaction by paying the balance amount for specific performance. Hence, I hereby direct you to receive the balance sale consideration at my client's office mentioned above within a week from the date of receipt of this notice, and to execute a sale deed said lands as mentioned so and so in favor of my clients. And now please see, they pick up just one para 2 is ignored, para 3 is picked up, reproduced in the judgment under review. And please see what the Supreme Court says. Please have para 60 on page 39. Yes, my lords, have para 60 on page 39. Have para 60.
Yes.
The notice dated 8/2/2000 issued on behalf of the purchaser implicitly acknowledges the fact that time was considered as the essence. Even by the purchaser themselves, and due to breach of the same, they sought novation of the agreement to sell in the following manner. Then that para is reproduced, which I read out of context. And then para 61, aforesaid notice at best reflects an intention by the vendor to renegotiate the terms, which was not accepted in toto by the vendor. Well, the whole case is about being disbarred and disentitled on time being the essence. The Supreme Court, contrary to the High Court, and I show your lordships the High Court judgment in detail, holds by time. So whole year. Show one more paragraph. Please have para 34 also now.
Subject to my filing a reply. No, I should be entitled to file if I'm entering appearance today.
No.
The matter is not
Letters to the registry.
I didn't want to get into this today. They have been writing letters to the registry, and on the last page, someone, just a minute, someone appears on their, just a minute, someone appears on their behalf and says, I'm not familiar, this matter has come up after so many days, we are not aware of who's there, who's not there, these people live on far off places. They take a date on that day, and today come before your lordships with 5 counsels to appear on their behalf.
Where's the tearing hurry?
And
the tearing hurry is that you should not deal with them properly.
The lordships have delivered a judgment. That is not a healthy practice. They filed in you, they kept without pushing it, they kept it in freeze, then without taking it. Then the other judge retired. The judgment of my lord, the chief justice.
My lords are well aware because of open hearing. Your
One
lordship,
minute, I
my
will
lord,
not
the
show
Chief
it.
Justice said there should be an open hearing. My lord Justice
Yeah, open
Kohli
hearing is
then
much
said
later.
no open hearing. My lord Justice Mishra concurred with the Chief
That's
Justice.
all right, but that's
Then
happening
there should be
now.
an open hearing.
You
That
are
is why
making-
this time was taken. Please don't make incorrect
Justice
statements.
Narasimhan.
And Justice
This is what
Narasimha
your plan
refused
is.
in the matter. That's why the time was taken.
Sir, the judgment is of 22. We are today in 24. If you were
Review
gonna
was
say,
filed within
you would have
limitation.
got the review listed at the appropriate time.
And you want to
Never
deal
did.
now with the property the way you want to. That's the
Anyway,
tearing
Lord,
hurry.
I want to put in a reply, but subject to that, I want to show you 2 or 3 things.
Yes.
Let me show you.
Manoj, can I show one paragraph which is important for your lordship?
This, you formulate in
Yes.
say a note of about 2 pages.
Yes.
You've already made clear what you want to argue in the review.
Yes.
But this ex facie,
Yes.
the judgment of Justice Krishna Murari suffers from an error apparent on the face of
Yes.
the record.
Yes.
You have formulated it.
Yes.
You give it to them.
Yes.
That's the point which you want to urge.
Right.
That's right.
You prepare a note on the basis of the record. We'll keep it on Friday. You give it to them
Yes,
by
fair enough.
tomorrow morning.
Yes.
Put it on the reopening.
No, my lord, keep it on Friday.
We
Please
keep
have
it
it on Friday. Yes.
They will, and they will be confined either
I will confine.
either we dismiss it on that because we have not formed a view.
I'm only asking for Monday.
No, my lord, Monday. No, please have Friday.
We will.
Manoj, I have some problem on Friday. If it can be Monday,
Why should it not be Friday?
next Monday. Manoj.
Let's not say much about
No, I
matter waiting 2 years. There's a lot to be said, which we don't want to say right now because that affects the dignity of the court. We will allow them to place on the record the short 2 submissions which they have made. We will not allow them to transgress those submissions on the point.
Fair
of view.
enough.
We are not with them. That's the end of the
If
matter.
your lordship wants Friday, then Friday.
Keep it on Friday.
Then I will circulate my note, my lord, by Thursday. Once I get their note.
Yes.
Your lordship may have.
Please. And my lord, in the meantime, let them not deal with the property and make my review in front
Paul,
of us.
Mr. Neeraj Kishan Paul has urged specific issues, 2 specific issues.
My lord, there's a third one also.
Mr. Kaul,
Yes.
you don't want to say anything about para 36 and 37?
That is all, my lords. I
didn't argue that.
My lords, I was about to come to that. That's the third one I was saying. That's all that I'm saying, that the section 55 of the contract.
Mr. Neeraj Kishan Paul, learned senior counsel, appears on behalf of the review petitioner. Full stop. Mr. Mukul Rohatgi appears on behalf of the first respondent. Mr. Mukul Rohatgi, learned senior counsel, appears on behalf of the first respondent, while Mr. Harish and Salve, learned senior counsel, appears on behalf of the second respondent. Full stop. The petitioners shall, the petitioners have clarified in the submissions of Mr. Neeraj Kishan Paul and senior counsel, the 3 grounds on which the review petition is sought to be maintained have been urged. Full stop. In order to bring clarity to the ambit of the review petition, we permit the petitioners to serve on the respondents by 5 p.m. Tomorrow a copy of the grounds on which the copy of the submissions on the basis of which the review petition will be pressed. Full stop. No further submission apart from what is set out in the note to be circulated shall be permitted to be urged. The respondents will be at liberty to respond to the note no later than by 5 p.m. on Thursday ka date list कीजिए. List on Friday.
And my lords, let them not create third-party interest in the meantime.
Let's have gone
My
back.
lords, this has happened many times. my lords.
Respondents shall not create any.
I don't know, my lord, whether we have or we have.
Shall not
All the more. All the more.
third-party rights between the date of this order and the.
That's fine.
Grateful.
on which the petition is.
Grateful. Very grateful.
Mr. Sibal, you're 38, right?
Yes.
37. Is the other side here?
Yes. Yes.
Mr. Shyam, Mr. Niranjan Reddy, they are not here, they are in legs in some other.
Already, when you're all here, just mention it, we'll take it up.
Well, it's 2 o'clock, the exam is. It doesn't
My
matter.
lord, students are already in the exam centers. 12:30 was the cutoff time. My lord, they are already inside right now. My lord, it's an interim order.
There's a very.
Mr. Sibal, at point of time, how can we create, there'll be a chaos if we intervene at this stage. The
So the
students are already in
problem
the
is-
examination center.
I appreciate that, but the problem is, Malaj, that whatever, the GO itself is ex facie against the judgment of this court. Ex facie.
Exam is to take place at.
But what do we do, Malaj? Therefore, all these people will be left out. Malaj, they'll be out. Many of them will be over it. After 14, kindly see. I just told only one fact. This exam has been held after 14 years. As per notice.
High Court has
One-
made.
Just allow me.
Let me see, but,
After 14 years, this exam has been held, Malas. The reorganization took place in 2014. 10 years after that, it is Group-1 post, Malas. It will never be filled again. So we lose our chance permanently. Now, Malas, I'm not asking for anything. We want only a postponement so that the matter can be decided so we don't lose out permanently. If they have waited for 4 years,
how do we postpone an examination for the Public Service Commission? Which would be extraordinary for us.
but thousands of persons are excluded.
Can-
And they are scheduled castes, scheduled tribes, contrary to Dipendra Yadav. Your Lordship knows, Malas, the adjustment. I understand.
Service Commission examination. We
Then,
can't-
Malas, they must allow us. They must allow us then,
result
because
is
we are
subject to the petition
candidates who have been discriminated.
We'll say that all further steps which are taken will abide by the further directions, including the further directions that may be issued by this court and subject to the result of these proceedings.
The High Court has already said that, my lord. The results are made subject to the result. Please have page 8 and 9, my lord. It's kept for final hearing on 2011, 2022.
The
2011,
High Court is
2022
still-
means what?
High Court
Exam is
still-
over, I will not be able to do anything.
High Court is still seized of the matter.
Yes, my lord. Counters directed to be filed. Public Service Commission already filed its counter. State is filing its.
That's not
counter
the
in 3
point.
days.
The point
My lord,
is,
21st October, my lord, the matter is being heard. High Court asked the commission, how long will it take? My lord, exams today, they said they need 3 months for the purpose of declaration of result. High Court assured them that the matter will be heard and decided, my lord, in the shortest possible time. It's coming up before, my lord, a very fine judge.
fine, Malas, and then no result because the result will be in 3 months. Let it be heard today.
But they are otherwise also going to take 3 months before the result.
Yeah, therefore the matter can be heard.
Therefore, if any order is passed, the results will be affected accordingly.
That's why I said, Malas, therefore I said that your lordships may have them decide the matter
Students have
before the 3 months result.
We'll say that the specially petition arises from an interlocutory order of a division bench of the High Court for the state of Telangana, dated 16 October 2024. Full stop. The High Court has specifically clarified that any selection which is made in pursuance of the examination which is to be conducted by the Telangana State Public Service Commission for Group-1 services.
Yes.
Group-1 services.
Shall abide by the final outcome of the proceedings. The proceedings have been listed before the High Court on 20 November 2024. So the court is apprised of the fact that the examination is due to commence today
Yes.
at 2 p.m. and students have already reported at the examination centers.
Correct, madam.
In this view of the matter, we are not to consider view that any further interim order in these proceedings would cause substantial dislocation in the conducting of the examination, which we are disinclined to do. So the High Court has already clarified that any selection which is made hereafter shall abide by the final outcome of the matter. Full stop. However, we request the High Court to earnestly endeavor to take up the petition
Before the results are
before
declared.
the results are declared, and preferably on 20 November 2024, when the petition is to come.
Yes.
Before the result is declared, my lord has said.
All right.
Mullahs, the only one further request, Mullahs, since some of us are not allowed to sit for the exam, supposing the High Court decides in our favor, at least, Mullahs, then at least some exam be
That
conducted.
the High Court can give you whatever age relaxation or something like that. That you can urge before the High Court. That's a question of modulating the release. 41.
Please, my lords.
Yes, Mr. Abdulson.
My lords, in this matter, this concerns the issue of the madrasas. Your lordships will recollect. Pleadings are complete in this, my lords. The compilations are ready. We're ready to argue, my lords. So, my lords, my submissions are on file, my lords. But before I start with those submissions, I'd like to share with my lords this communication, my lords, from the National Commission for the Protection of Child Rights. And with respect, I'll point out, my lords, that this communication is subsequent to my lord's interim order, very detailed order. This is subsequent to that order. May I just read this out, my lords?
For relocation of the students, right?
Yes, my lords.
This morning we have stayed a series of communications of the NCPCR.
Yes, except this, my lords. This was not stayed in the morning. I was here at item 10 with the unaided madrasas. This was dated 11th October 2020.
But you asked your main matter now. This is in consequence of the two orders which we have stayed, right?
Yes.
After the orders of
After.
our court stay.
Yes.
Now you open your case, you tell me what your
I will, my
contention is.
Grateful, grateful. My lords, my written submissions, my lords, are on file. If my lords will, there are 4 sets of submissions from 4 councils.
Are they in the additional diary?
My lords, this is volume 1, written submissions.
Yes,
with
we
the
got
petitioner.
volume 1.
Yes. And mine start, my lords, because my propositions are listed there at page 33.
Yours is volume 1, right?
Volume 1, my lords. Volume 1 for the petitioners, my lords.
Yes.
Yes. My lords have that.
Dr. Guruswamy, yes.
Yes.
Page 33.
33 onwards, my
Yeah,
lords. Fairly brief submissions. My lords, before I take you to my propositions, I just want to make one point.
Can
Before
you
I
show us the act? Can you
Yes.
show us the act? It's a
Yes.
state act, right?
Yes, my lords.
So can you tell us the ambit of the state act?
Yes.
What that act really does and what the High Court has held? I think in our interim order, when we issued notice and we
Yes.
stayed the judgment of the Allahabad High Court, we had formulated the points which.
That's right, my lords. My lords, so shall I start with the act then, my lords?
Let's look at the act
Yes.
first, because
This is
in
volume.
a PIL, the High Court has set aside the entirety of the act.
Yes. Yes.
Am I right, Mr. Natraj? The High Court set aside the act.
That's right.
Though as a matter of fact, the state of Uttar Pradesh had supported the act as a legislating
It's
body.
our legislation.
Yes. So, my lords, I'll take you straight away to that. But before that, if you just go to page 35 of my submissions, I have extracted the act there, my lords.
35 of your
35 of the submissions, of my own submissions, 2 pages over, my lords.
Yes.
The propositions were at
Object and purpose.
Yes, yes. So, my lords, may I just take you, my lords?
When we come back after lunch,
Yes.
just give us the bare act.
Very well.
If a soft copy of the bare act is there, because that's the essence of
It's in volume 4A, my lords. I'll take you through that. Page 33, volume 4A. I'll take my lords to that.
Page 33, volume 4A.
Yes, page 33, volume 4A, my lords.
Yes, we have it here.
Yes. My lords, please see, my lords, the object and purpose. Page.
We'll come back after lunch.
Yes, my lords. Grateful. Grateful.
Just about 15 minutes. What is the essence of the challenge?
Absolutely, my lords. Grateful. I will.
My lord, may I make one submission? I just heard from my lords only that there are some more communications, some issues are also pending against NCPCR, which was stayed. We were not advanced, so I'm not aware. If issues are similar, can we have all together?
Not necessary. The High Court has set aside the validity of the act.
Lordship.
We have to see if the High Court is right. That's all.
Lordship.
Lord.
Yes, Dr. Goswami.
My lords,
Not at now.
item 37,
Sorry, not.
appearance slip will be.
Appearance slip. Yes, yes, of course. Appearance slip.
May I take my lords to the statute immediately? Volume
Statute
4A.
actually do.
Yes. It's volume 4A, my lords, statutes of the petitioners.
Yes.
My lords all have that, my lords.
Yes.
Starts at page 33. Your lordships will see the Uttar Pradesh Board of Madrasa Education Act 2004. This was the statute that was struck down in the impugned High Court decision, my lords. Now, the Uttar Pradesh Board of Madrasa Education Act 2004 is a regulatory statute. It is a regulatory statute that seeks to enhance the efficiency and excellence of madrasas all over the state of Uttar Pradesh, which are aided. And in doing so, through a detailed regulatory roadmap, the statute, in fact, upholds and serves the mandates of Articles 28(1) and Articles 31 of the Constitution of India. The High Court, by taking suo cognizance of these issues, what should have been a service law dispute. Yes, my lord. This matter at the High Court initially starts as a service dispute by an assistant professor who is contesting a certain monetary valuation of his wages, 4,000 rupees. That is how the list starts. The High Court then takes suo cognizance of this and with respect wrongfully strikes down a regulatory roadmap which, if anything, seeks to enhance the educational excellence that is provided by madrasas all over Uttar Pradesh and that till date educate 17 lakh students and employ 10,000 teachers. Please allow me, my lords, to take you to this detailed regulatory roadmap.
Let's have a look at the functions of the board in section.
Yes,
9.
my lords. Certainly, my lords. So,
The rest we will see on our own. I mean,
Yes,
it constitutes
yes,
a
yes.
board and things like that. But the crux is section 9.
Yes, my lord. Section 2A is board and 9 is the crux. It's the heart of the statute and the heart of this case.
Constitution भी दिखा.
Yes, yes. My lords, 2A is the board itself and section 3, as my learned friend rightly points out, is the constitution of the board. Your lordships have that at page 35.
Yes.
Yes. May I read, my lords? Constitution of the board, section 3. With effect from such date as the state government may by notification appoint, there shall be established at Lucknow a board to be known as the Uttar Pradesh Board of Madrasa Education. 2, the board shall be a body corporate. And 3, please see, the board shall consist of the following members. A to N, my lords, is a detailed, multi-pronged, deeply specific constitution of this board specifying which educational heads, for instance, 3K, 3K, one science or tip teacher of an institution nominated by the state government, the account and finance officer in the Directorate of Minority Welfare, Uttar Pradesh, the inspector, N, an officer not below the rank of deputy director nominated by the state government.
Director of Education, the Director of
My
Minority
lords,
Welfare.
3B, the director who shall be the vice chairperson of the board. C, the principal government Oriental College,
Let's
Ram.
see the functions now in section 9.
Yes, my lords.
BF is the representative of National Council for.
Yeah, I saw that.
Yes, my lords.
NCR.
3F, my lords. One representative of National Council for Educational Research and Training.
NCERT.
NCERT. These are all the members of this board. And section 4, my lords, may see, there shall be, this is page 36, maybe after the election and nomination of members of the board are completed, the government shall notify that the board has been duly constituted and the notification is provided for. Section 5 on the same page 36 provides for a term of office of these members, and 6 and 7 on pages 37 provide for filling of vacancies and even meetings of the board. This is very much in consonance with how the roadmaps of other educational frameworks in this country are fulfilled. Now, my lords, section 9.
You mean subsection? Subsection 4 and 5 of 3?
Yes, my lord. No, my lords, this is section 4 and 5, my lords. Sections 4 and 5.
Section 4 is removal of members.
Yes, my lord. Section
5 is term of office.
Term of office. Yes, my lords. Section 4 and section 5 on page 36, my lords. And section 6 at 37 is filling of vacancies of expiry of term of office. And 37, section 7 is meeting of the board.
Yeah.
Now, please see, my lord, section 9 on page 37, the functions of the board. And this is very important, my lords, with respect. Subject to the other provisions of this act, the board shall have the following functions, namely, A, to prescribe course of instructions, textbooks, other books, and instructional material, if any, for Tahatanya, Fawqania, Munshi, Maulvi, Alim, Kamil, Fazil, and other courses. And these are all the grades of instruction, my lords. So the first one, my lords, Tahatanya, is primary education. And therefore, this breaks up. A Munshi is a expert in teaching Persian.
It's a recognizing institute. It's a recognizing board as well, because the board has the power to affiliate institutions.
Yes, my lords.
Then it can hold examinations. It can prescribe courses of study.
Yes.
It can prescribe books of study, so on and so on.
That's right, my lords. And my lords, there are regulations under the statute, which in fact speak to instruction of math, social sciences, and other such subjects, which we consider to be essential education in this country. I'll take my lords through those regulations. Please see, my lords. 9B prescribes course books, other books, instruction materials of courses of, my lords, Arabic, Urdu, Farsi for classes up to. C, my lords, to prepare manuscripts of the course books, other books, and instruction material referred to in clause B by excluding the matters therein wholly. D, prescribes the standard for appointment of Urdu translators in various offices of the state. E, the granting of degrees, diplomas, certificates, and other academic distinctions to persons who have pursued a course of study in an institution admitted to the privileges and recognition by the board. Very important, my lords. And subsection 2 of E, subclause 2 of E, have studied privately under conditions laid down in the regulations and have passed an examination of the board under like conditions. F, my lord, speaks to examinations of the Munshi, Maulvi, Alim, Kamil, and Fazil courses. So even these instructors and instruction mechanisms have examinations prescribed, which the board will conduct. G, to recognize institutions for the purposes of its examination. H, to admit candidates to its examinations. I, to demand and receive such fee as may be prescribed in the regulations. I'll take my lords to those regulations. Now, JKL, my lords, very important, to publish and withhold publication of the results of its examinations wholly or in part. K, to cooperate with other authorities in such manner and for such purposes as the board may determine. L, to call for reports from the director on the condition of recognized institutions or of institutions applying for recognition. M, to submit to the state government its views on any matter with which it is concerned. N, to see the schedules of new demands proposed to be included in the budget relating to the institutions recognized by it. Your lordships will remember the constitution of the board includes an audit officer who is in fact on this board. So you'll see the linkages of how this statute seeks to better administer these institutions. N, my lords, to see schedules of new demands proposed to be included in the budget relating to the institutions recognized by it, and to submit, if it thinks fit, its views thereon for the consideration of the state government. O, to do all such other acts and things as may be requisite in order to further the objects of the board as a body constituted for regulating and supervising madrasa education up to Fazil. P, to provide for research or training in any branch of madrasa education. And my lords, these are the various branches and these are the various colleges. Q, to constitute a committee at district level consisting of not less than 3 members for education up to Tahatania or Fawqania standard, to delegate such committee the power of giving recognition to the educational institutions under its control, are to take all such steps as may be necessary or convenient for or as may be incidental to the exercise of any power or the performance or the discharge of any function or duty conferred or imposed upon it by this act. Now, please see, my lords, the powers of the board. And this is very, very crucial, my lords. The powers of the board. 1, the board shall, subject to the provisions of this act and the rules made thereunder, shall have all such powers as may be necessary for the performance of its function and the discharge of its duties under this act or the rules or regulations made thereunder. In particular, and without prejudice to the generality of the foregoing powers, the board shall have the powers to, sub 2(1) now, my lords, to cancel an examination or withhold the result of an examination of a candidate, or to disallow him from appearing at any future examination who is found by it to be guilty of, for the A, using unfair means in the examination, B, making any incorrect statement or suppressing material information or fact in the application form for admission to the examination, C, fraud or impersonation at the examination, D, securing admission to the examination in contravention of the rules governing admission to such examination, E, any act of gross indiscipline in the course of the examination. Subclause 2, my lords, to cancel the result of an examination of any candidate for all or any of the acts mentioned, and subclause 3, to prescribe fees, and subclause 4, as my Lord the Chief Justice mentioned, to refuse recognition of an institution, A, which does not fulfill or is not in a position to fulfill or does not come up to the standards for staff, instruction, equipment, buildings laid down by the board in this behalf, and B, which does not or is not, this is page 39, my lords, willing to abide by the conditions of recognition laid down by the board in this behalf. So, my lords, we've seen the qualifications for those who shall instruct in the earlier parts of the statutes, who comprises the board, the connections of the board to the state government prescribed by the statute, and now, as detailed as this, the regulation of the exams, who can even enter the exam hall, under what conditions, and D, my lords, who can in turn be recognized by this statute in terms of other institutions. Now, please see, my lords, section 13. And this is the power of the state government.
11 first, recognition.
Recognition, yes, my lord.
To prior
Section 11.
approval of the government.
Recognition of an institution in any subject or for a higher class, notwithstanding anything contained in subclause A, clause 4 of subsection 2 of section 10, the board may, with the prior approval of the state government, recognize an institution in any new subject or group of subjects for a higher class. And section 12 pertains to proper utilization of donations that are made, my lords. This is a very detailed provisions on how you...
Section 13.
Correct.
Yes, my lords. Power of the state government to issue direction. May I just read that, my lords? This is also on page 39. 1, subclause 1 of section 13. The state government shall have the right to address the board with reference to any work conducted or done by the board, and to communicate to the board its views on any matter with which the board is concerned. And 2, my lords, the board shall report to the state government. Here is the interplay institutionally, my lords. So the state government can legislate the statute under the concurrent list. The state government can, in fact, once the statute is passed, a roadmap is established for how the board shall interact in depth with the state government. Please see this, my lord. Subclause 2, the board shall report to the state government such action, if any.
All right, we've got the drift of it
Yes,
now.
my lord.
We can just sort of look at some of the other provisions, the marginal
Yes.
note. Section 22 provides for the scheme of administration.
Yes, my lords. Yes, my lords.
23 provides for appointment of heads of institutions, teachers and other employees
Yes, my lords. And my
in
lords,
accordance with the regulations.
section 20.
20 you were saying.
20, my lord, speaks to the power of the board to make regulations.
Regulation.
And
Yes.
I'll only take your lordship subsequently to one page of the regulations, which is at page, if my lords could just mark this. This is at page 171 of the same volume.
All right.
And these are regulations which were brought in by amendment, which says that teaching of all subjects to be imparted. And this includes, my lords, math, science, social science, computer. And the medium of instructions shall be Urdu, Hindi or English as the case may be. This is on page 171, my lords. We have extracted and we have put in the regulations that have been passed by virtue of this statute. Now, my lords, may I just...
At the end, the statement of objects and reasons.
Yes, my lord.
I saw that. It's an act of 1987, the rules of 1987.
Yes, your lordships have seen that, my lords.
देखा वो आपने?
Yeah. 43 would my lords like to see? Yeah, my lords, 43 is for the ordinance, which existed prior to the statute.
Into the
Yes.
act and
Yes, my lords, converted into the act.
same statement of objects
That's
will accompany the bill.
Now, my lords, what is the constitutional marker for whether this
Now
regulatory
tell us what is
roadmap?
weighed with the High Court. Why does the High Court hold this to be unconstitutional? Basically, the Act is very clear. The Act provides for setting up a board. It will regulate the course content. It will regulate the conduct of examinations, the award of degrees and diplomas.
Yes, ma'am.
Admitting institutions to the privileges of the of which are available under the statute. The conditions of service of the teachers and other employees. Then the making of regulation. Now, it's broadly a regulatory statute.
Regulatory. It is only a regulatory statute.
It is now, what weighed with the High Court?
My lords, two things, my lords. They conflate regulation. They conflate regulation with religious instruction and therefore violating basic structure. And this respectfully is absolutely wrong.
Basic structure?
Secularism. Violating secularism.
Violates
So,
the principle of.
Violates the principle of secularism is what the High Court says. That
Article 30 expressly recognizes
Yes, ma'am.
linguistic and religious minorities.
That's right, my lord.
The right to establish and administer educational institutions.
That's right.
The point seems to be, I remember while reading this earlier when we issued notice,
Yes.
they said that the state cannot fund
Yes.
because they must be receiving aid from the state.
That's right.
But the board does not receive any aid from the state, right?
No, my lords. The board does not. And in fact, 28(1).
Institution.
The board does not. But my lords, your lordship, my lords, 20, Article 28(1). And this is the conflation that of the Constitution. This is the conflation that the High Court makes.
Now formulate what weighed with the High Court.
Yes.
Just 3 bullet points. And
Yes.
you can address us and why the
Yes.
High Court is wrong.
My lords, while the constitutions arrive, one, the High Court wrongly conflates regulation with religious instruction, and thereby it says that religious instruction violates secularism as provided for by the Constitution. This is the first prong. So the conflation of regulation with religious instruction is in fact patently wrong, one, from an examination of the statute. Article 28(1), which says that no religious instruction shall be provided in any educational institution wholly maintained out of state funds. And Article 30.
The board is not providing for any.
Board is not, my lords. And the board does not
Affiliated
provide.
body.
Yes. The board provides a general education, which as the regulations show
But
includes.
most important, the board is not an authority which provides for education. It is regulating the character of
That is-
institution which
yes,
we affiliated.
so great. Yes, it is only a regulatory mechanism, which in fact we should be invested in if we are invested in excellence of educational institutions, including madrasas. So, my lords, may please see, my lords, and Article 31, right of
See, at the same time, the state does have a vital interest in ensuring that a certain quality of education is provided in the madrasa.
And I will take my
So, because even Article 30 contemplates that the state can make regulations to further the excellence of education.
In fact, your lordships of the Supreme Court have said, my lords, from All Saints onwards, a three-judge bench decision, 1980, your lordships have in fact said that whereas minorities can establish and administer, the state is invested in maintaining excellence and therefore can regulate.
Undoubtedly.
This is, and I'll take my lords very briefly to both
So
those
therefore,
cases.
things like, Frank Anthony, prescribing the scales of pay,
Yes, my lord.
conditions of service for teachers, security of tenure, so on and so forth.
Yes.
They may also have a vital interest in ensuring, for instance, that, these are young children who come into the madrasas.
Yes.
That they must be able to have some broad-based education.
Yes.
Where apart from, of course, religious instruction, that they learn the essentials of all the subjects required to lead a proper life
That's
once
right.
you get out of the education.
Regulations speak to that, my lords. The regulations, in fact, understand. The statute we've gone through, my lords, the regulations, in fact, understand that not only will you be exposed to the philosophy of religions, which is permissible, constitutionally permissible, but you will also be imparted in education and social science, in computer science, in math, in English. This is also what these educational institutions do. And we have to confront the reality that in a state as large as UP, these are critical. I'm sorry, Madam. 2H. I'll take them there. So that in a state as large as the state of Uttar Pradesh, these madrasas which are regulated by the board, which in fact there is an interplay with the state, provide a vital educational role and ensure that there is access to education. Your lordships will see, my lords. May I just
2H.
2H.
Other branches of learning as may be specified by the board from time to time.
Yes.
Board has now specified.
Yes. Madrasa education means means education in
Has the board specified other branches of learning?
Yes, my lords. 171 regulations, my lords, at page 171. May I just take my lords there to page 171, the same compilation, my lords. 171. My lords all have that, my lords. This is the page 171, same volume 4A, my lords, of the statute compilation. The Uttar Pradesh non-governmental Arabic and Persian Madrasa Recognition, Administration and Services, Second Amendment Regulations 2018. The preamble, my lords, that it speaks to a certain amendment, short title, these regulations. Now, please see.
They say education in English, math, science, social
Yes,
studies,
my lord.
computer, etc. Teaching of all the subjects can be imparted.
Can be imparted.
Does this mean that each madrasa has the discretion whether to impart or not to impart?
My lords, in fact, the
Instruction, yeah. Issue instructions, right?
yes, the board and once the board is regulating, since you have this regulatory body on top, my lords, the discretion of the madrasas is removed to that extent. Because the board is in fact ensuring.
But has the board directed that, for instance, there will be education in other secular subjects like math?
Yes, my lords, per the regulations itself. So today.
Where is that?
Page
triple eight of this.
May I just finish reading the regulation, my lords?
Page triple eight. Just read triple eight.
Yeah.
also has the power to issue direction.
That's right, my lords. We
So the state
actually saw
government-
section 30.
The state government would, I mean, you can concede to this, that the state government also has a vital interest in ensuring that all children who are receiving, say, primary, secondary, or higher secondary education fulfill certain basic requirements of a course of study. For instance, they must learn these basic subjects so that they become worthy citizens once they leave these institutions.
Yes.
That they are employable.
That's right, my lords. May I just take my lords to volume 3A? This answers, my lord, the Chief Justice's question. Volume 3A, documents of the petitioner, page 888, 888. This is a circular, my lords, regarding teaching of modern subjects in madrasas. This is volume 3A, my lords. My Lord Justice Pardiwala has this, my lords.
Yes.
This is volume 3A. My lords all have this. May I just read this, my lords? It is dated 15/5/2018, Uttar Pradesh Madrasa Education Board, Lucknow, letter number so-and-so. Subject, regarding implementation of NCERT textbooks for teaching modern subjects in madrasa, recognized by Uttar Pradesh Madrasa Education Board. With the aim of bringing educational upgradation, standardization, and uniformity in the Arabic Persian madrasas of Uttar Pradesh, it has been decided in the meeting of the Uttar Pradesh Education Board dated 15/5/2018 that in order to ensure uniformity, equality, and upgradation of education in mathematics, science, English, Hindi, computer science, social science, etc., in all the madrasas, the curriculum will be based on the available textbooks of NCERT for the said subjects to be included in. Therefore, being informed as per the above decision, please take efforts to ensure the above mentioned action in the academic session 2018-2019. Now, my lords will see, my lords, 915. May I just take my lords to pages 915, the same volume, my lords. These are 917. 915, my lords. These are minutes of the board meeting. Yes. My lords have that, page 915, same volume, my lords. My lord, the Chief Justice also has.
Yes.
May I read, my lords? This is minutes of the board meeting held on 12th October 2021 under the chairmanship of the Honorable UP Madrasa Education Board. And these were the members present, my lords.
Yes.
Now, may I take my lords to page 917, paragraphs 7.1 and 7.2. May I just read this, page 917. Other points with the permission of the Honorable Speaker. The board was informed, this is one, my lords, the board was informed by the registrar that as per the provisions given in the Uttar Pradesh Madrasa Act 2004, there is a need to reconstitute the subcommittees of the council like Recognition Committee, Curriculum Committee, Examination Committee, and Result Committee. On this, the board agreed to form the said committees in the upcoming meeting. 2. After extensive discussion regarding the curriculum implemented in madrasas, the council unanimously approved the inclusion of elementary maths and elementary science, history and civics as compulsory subjects from class 1 to secondary level. As per the NCERT curriculum, consent was granted.
Now, where do we have on the record the prospectus or the a course brochure or something
Yes,
like that?
We do, ma'am.
Let us see what is
I'll
taught.
take my lords to the syllabus, the syllabi.
Let us see that.
892. Order has it at 72, 73.
890.
Get the original document, better. Page?
892, my lords, of the same volume, my lords. These are, my lords, syllabus and books of the Uttar Pradesh Madrasa Education Board, my lords, classes 1 to 6. So this is serial number, class, syllabus, my lords, books, date of enforcement of the syllabus, my lords. Your lordship sees those 4 columns, my lords, 5 columns. And the syllabus, books, and date of enforcement continues, my lords, 892, 893, For instance, my lord, 893, you'll see, my lords, the detailed workbooks, Spring, Sanskrit, Sudha, etc., my lords. Sanskrit is also being taught, my lords, in the madrasas. 894, Vatika, Gyan workbook, Prakriti workbook, Petals, Sanskrit, Subodh workbook, Sanskrit, Subodh, etc., my lords. Now may I, and this continues, your lordships will see, my lords, there's a detailed breakdown of the syllabi and the textbooks to be used, because these textbooks, my lords, are very detailed.
Like this is an annexure to this letter at page 889.
Yes.
Ms. Monica Garg, Principal Secretary, Government of Uttar Pradesh, where she
Yes.
said that, modern subjects were not being taught in the madrasas.
Yes.
Therefore, the board then resolved to teach the modern subjects as well.
Yes, my lords.
And
my lords, 898, this is the syllabus for secondary classes, my lords. And you'll see, my lords, again, similarly, textbooks, dates of enforcement, there is prose, history of Arabic literature, grammar. This is not religious instruction, my lords. There's poetry and translation at page 901. And page 902, your lordships will see middle of the page, general English, prose and poetry, English reader course, SCERT, which is the state textbooks, class 10. This is at 902, my lords.
All right.
Page 902, serial number 4. My lords all have it,
Yes.
my lords. General English, prose and poetry, English reader, course SCERT, which is the state board, class 10th, 8/1/2023. Below that, 5, my lords, general Hindi, prose and poetry. It shows you again, it's the textbook which is used in the state institutions, SCERT. Then please see, my lords, 6. Optional subjects, select any one of the following. Math, my lords, Rivaji, Hissa, Aval. This is again the state, my lords. My only objection here, my lords, is serial number 2 is home science only for girl candidates, my lords. I'm not sure why that's the case, my lords. 3, logic and philosophy. 4, social science. This is bottom of the page, 903, my lords. This is social science, again, as per the state board, SCERT.
Right away, in this time when we had our cultural meet for almost 2,200 employees of the Supreme Court, we made sure that there would be no event which would be barred for women, but no event which would be barred for men. So Antakshari and cooking were also for the women, for the men, and the women ran the half marathon or the marathon also.
True equality.
And football and whatever.
049.
Get this, uncle, and all that we've seen this. We had a flavor.
My lords, medical science, 904, my lords. Again.
The date of the impugned judgment of the High Court.
The date of the impugned judgment, my lords.
Is 22 March 2024.
22nd March.
Yes, sir.
2024.
And medical science.
Yeah.
Including regulation.
Can you just show us the relevant paragraphs of the judgment?
Yes, my lords.
Let's go to the judgment.
Yes, my lords. May I first take your lordships to All Saints, my lords? This is volume 4A.
No, forget the judgments on articles.
The impugned judgment. Yes, my lords. Certainly. Certainly, my lords. My lords, the impugned judgment, this is volume
the main dice.
3A, my lords. Volume 3A, page 8, my lords. So,
3A, page 8.
Yeah, PDF 8 and page 8, running page 8. Submissions. No.
B 33 is with regard to locus.
Paragraph 33, page 30, my lords. This is on locus. Please see, my lords. Paragraph 33, page 30.
34 locus and
Yeah.
reading.
33 and 34 are locus, my lords. This is when he took suo moto cognizance. So This is a petition filed by an advocate. Please see paragraph 34, my lords. I'll just read that. Which challenges the virus of this act, which the regulatory statute.
So there was a substantive petition challenging the virus of the act also?
Yes, my lords.
It was not thrown. It was on a batch of petitions. Please see the first page.
Fair enough, that may be so.
May I just read paragraph 34, my lords? No material is placed before us to show that the petitioner, an advocate who is a regular practitioner in this court, does not have bona fide intentions in filing the present writ petition. There is no reason to disbelieve his intentions. Further, the cause raised by him is a genuine cause.
It's not really just a suo motu petition. There seems to be a writ A actually.
But this is what was picked out, my lords. Out of this batch, what starts initially as a service matter.
What the High Court has found to be
Yes.
objectionable.
Page 72, my lords.
Dr. Guruswamy,
Yes, ma'am.
come back to para 34.
Yes.
And you read last 3 lines, that seems to be the argument. If a substantial number of children of the state
Yes.
are denied universal quality education, it would in future result in social and economic disparity in the society. Those denied the benefits of modern quality education would find themselves stuck with limited options of growth and livelihood. It
Madam.
seems High Court has proceeded on this footing.
Yes.
If there is no quality education, what is being imparted is only something religious, and therefore we deem fit to take so much.
Yes, Manas. I
Correct.
got on to that.
So
That's-
that seems to be the basis of it.
My lord is absolutely right, because the last 3 lines say this, my lords. In the
Right.
present case, it is not only the petitioner who has raised the issue, who has raised the cause of these children studying in madrasa,
So we keep this.
but this court itself
Right.
found a need to look into this issue. Now, my lords, may I take you to the operative portions?
Paragraph 53. Yes.
Para 53, my lords, of the judgment,
So page 51.
page 51. Page 51, my lords. It starts at page 51, grounds of challenge. My lords have that. Violative of secularism. This is bottom of the page, my lords, bottom of page 51. So the first prong, my lords, which is a ground of challenge for the court, is violative of secularism, para.
There is a discussion, they
Yes.
cite Bommai, that's
Yes,
fine.
my lords. It cites SR Bommai. It extracts SR Bommai.
Where are you reading?
My lords, this is page 52, my lords. Page, volume 3A,
Yeah, no, paragraph, which
paragraph 54 at page 52.
54.
Yes, my lords. I'm sorry, my lords.
Violative of secularism.
Violative of secularism.
Correct.
Yes, and that is one of the principal prongs on which the High Court strikes down the regulatory statute. Your Lordship will see, my lords, the extracts, Justice Sawant's decision, Justice Sawant's judgment, summarizing Justice Sawant, then you have Bommai extracted. My lords, so the extraction continues.
Till 69.
This extraction continues till page 69. May I just take you to page 69?
Actually, the discussion begins at para 63 at page 70.
Yes, my lords. And 62 as well, my.
62, yes.
Yes. Yes, and I'll just read the last few lines before I go to this paragraph 63. Bottom of the page, my lords, the concept of the secular state is essential for successful working of the democratic form of government. Now, please see, my lords, paragraph 63. It is in the aforesaid concept of secularism that this court is to judge upon the constitutional validity of the Madrasa Act. The history and statement of objects and reasons of the Madrasa Act shows that the initially private Arabi Farsi madrasas were established by some persons which were unregulated. Executive directions for their registration was issued for the first time in the year 1969. Later in the year 1987, non-statutory rules were framed for their regulation. A separate minority department in the state government was created on 12/8/1995, and on 31/1/1996, the work of madrasas was transferred from the education department to this new minority department. The earlier non-statutory regulations of 1987 were replaced by the Impugned Madrasa Act of 2004 with a view to, quote, remove the difficulties arisen in running and improving the merit in the madrasas and to make available the best facility of study to its students. The aims and objects of the Act is silent as to how and why requirement arose to have a separate education board for a particular religion while there are secular primary education.
If you can just break your link for a moment.
Yes.
Go to para 65, the last sentence, because before that in para 65,
yes,
they look at all the syllabus for the primary
That's right,
classes. Then they say in the last sentence,
it is admitted.
It is admitted by both the state and board of madrasa that Islam is a religion with all its prescriptions, instructions, philosophies, and deliberations is taught in its recognized institutions. Then, para 66 is important.
Yes, yes, my lord. May I read that, my lord?
Yeah.
Para 66. From the aforesaid, it is clear that under the provisions of the Madrasa Act for being recognized by the Madrasa Board, it is compulsory for an institution to be set up as a Muslim minority institution, and it is also compulsory for a student of Madrasa to study in every class Islam as a religion, including all its prescriptions, instructions, and philosophies to get promoted to the next class. The modern subjects are either absent or are optional, and a student can opt to study only one of the optional subjects. Thus, the scheme and purpose of the Madrasa Act is only for promoting and providing education of Islam, its prescriptions, instructions, and philosophy. This fact is and the board and is also not disputed by any of the respondents and interveners. Then, my lord,
so what is the basis for the High Court to arrive at this?
My lords, nothing on the record should have led the High Court.
Any material?
No, my lords, nothing on the record that was before the High Court should have led the High Court to come to this conclusion.
Second question. From where does the High Court say that the modern subjects are either absent,
yes,
are optional, and the student can opt to study only one of the optional
My lords,
subjects?
the High Court should not have come to this conclusion as I took my lords through the details of the modern subjects that are taught. There is again a conflation, my lords, respectfully by the High Court of madrasa regulatory, a statute that regulates education in the madrasas with a statute that in fact seems to provide for religious instruction. This is the conflation by the High Court. Therefore, the High Court concludes that secularism is violated. Respectfully, my lords, this conflation, there is nothing on the record that should have led the High Court to arrive at this conclusion.
Now see, para 68.
Yes, my lords.
The state, actually the government defended the statute.
Initially, yes, my lords. Initially, the government defends the statute.
Means throughout the proceedings before the High Court, they defend.
Throughout the High Court, my lords. And here
Para
the government.
68.
Yes, my lords.
Actually, you can see para 67 because that's important.
Yes, my lords. I'll just read that, my lords. Para 67, page 65 at the bottom of the page, my lords. To provide education, my lords all have it. To provide education, more particularly for minors, that is children up to the age of 18 years, is a constitutional duty of the state. Under Article 21A, state is bound to provide compulsory and free education to children between the ages of 6 and 14, that is from classes 1 to 6. Further, it is the duty of the state to provide education which is secular in nature. It cannot discriminate and provide different type of education to children belonging to different religions. Any such action on part of the state would be violative of secularism, which is part of the basic structure of the Constitution of India. Such an action on the part of the state is not only unconstitutional, but also highly divisive of the society on religious lines. To maintain unity in the society is a primary duty of the state and all its authorities. Any policy of the state which is divisive of the state on religious lines is violative of constitutional principles. Where any legislative act of the state is violative of the basic structure of the Constitution, one of the core principles of which is secularism, it is bound to be struck down. Para 68. The defense taken by the respondents, including the state government and the Madrasa Board, is that the state has sufficient power to frame laws with regard to education to be provided at school level, including traditional education. It is argued that in exercise of its powers under entry 25 of list 3 of schedule 7 of the Constitution of India, state has enacted the Madrasa Act. It is claimed that while having the power to legislate for education, it also has sufficient power to legislate on traditional education. And since religion is part of traditional education, therefore state government can legislate on the same also. Further, in case this court finds any provision of the Madrasa Act to be violative of the Constitution of India, it may only strike down such provisions and may save the remaining portions of the Act. The entire Act may not be struck down by this court. Further reliance is placed upon Articles 25 to 30 of the Constitution of India. The board and other respondents, while adopting arguments of the state, have further submitted that Articles 25 to 29 provide rights to propagate religion, and under Article 30, the rights of minorities to establish and administer their educational institution is specifically protected. They submit that state government has sufficient power to establish a board for religious education of a minority institution. Para 69.
70, 25, 29.
His reasoning. No, we don't have. May I continue, my lords? Para 69. No, page 74. No doubt the state has sufficient power to frame laws with regard to education to be provided at school level, both primary and thereafter up to intermediate. However, such education has to be secular in nature. The state has no power to create a board for religious education or to establish a board for school education only for a particular religion and philosophy associated with it. Any such action on part of the state violates the principles of secularism, which is in the letter and spirit of the Constitution of India. The same also violates Article 14 of the Constitution of India, which provides for equal treatment to every person by the state. Para 70. This is important, my lords. So far as Articles 25 to 29 of the Constitution are concerned, the same relates to the rights of citizens and not those of the states. It is the citizen of this country who have the right to profess and propagate their religion and its values. It is not mandatory for a citizen of this country to be secular by nature. He can have faith in his own religion or in every religion, or may not have faith in any religion. But the state cannot do so. The state has to remain secular. It must respect and treat all religions equally. The state cannot in any manner whatsoever discriminate between religions while performing its duties. Since providing education is one of the primary duties of the state, it is bound to remain secular while exercising its powers in the said field. It cannot provide for education of a particular religion, its instructions, prescriptions, and philosophies, or create separate education system for separate religions. Any such action on the part of the state would be violative of the principle of secularism. This is the essence.
Come straight to 83.
83, my lords.
83.
So that's Article 21 and 21A.
That's the finding.
Yes, my lords.
Read it.
May I just read that, my lords? Paragraph 83.
From the above
Discussion, it is clearly established that education under the Madrasa Act is certainly not equivalent to the education being imparted to the students of other regular educational institutions recognized by the state primary and high school and intermediate boards. And therefore, the educations being imparted in madrasas is neither quality nor universal in nature. So this is the heart of the
court is comparing the students of madrasa with other students.
My lord.
And it's trying to convey that this is violative of Article 21 capital A.
My lord.
Para 84.
Yes, my lords. While the students of all other religions are getting educated in all modern subjects, denial of the same quality by the Madrasa Board amounts to violation of both 21A as well as 21 of the Constitution. The state cannot hide behind the lame excuse that it is fulfilling its duty by providing traditional education on nominal fee. The Supreme Court has repeatedly emphasized on modern education with modern subjects and education that is universal in nature, that prepares a child to make his future bright and to take this country forward. It does not prescribe by any stretch of imagination limited education with emphasis only upon a particular religion, its instructions and philosophies. Education being provided by the Madrasa Board, therefore, is in violation of the standards prescribed by the Supreme Court while interpreting constitutional provisions. Therefore, this court has no hesitation in holding that the education being provided under the Madrasa Act is violative of Article 21 and 21A of the Constitution of India. So your lordships will see, my lords, even in page 84, in paragraph 84 and in the paragraphs above, the equivalence is made wrongly, my lords, respectfully by the High Court, between madrasas imparting religious instructions and therefore violating secularism.
Now, that's the second aspect. Now, third aspect is a conflict with the UGC Act, the High Court has dealt with.
Yes, my lords.
So, what is that finding?
Yes, my lords. My lords,
Right,
finding.
85 and 86.
Yes. So, my lords, this portion of it starts at page 74, bottom of the page 81, bottom of the page, and the findings.
Do the madrasas trench into any area which is reserved for the UGC under the UGC Act?
No, my lords. Was the conclusion of this. Where is the conclusion? Paragraph 99, my lords, the conclusion. And this is at page 92. Conclusions are at the bottom of the page, my lords.
But these madrasas are up to which standard?
Plus 12, my lords. It's 1 to 12.
UGC talks about right to confer degrees. So what role UGC has to play up to 12th standard?
May I just take instructions?
Does High Court say there is a conflict between the Act and the UGC regulation?
Para 96 might help.
96 and 97, what they say is
That's right.
that section 9A of the Madrasa Act confers power on the board to prescribe courses of instruction, textbooks, other books and instruction material, even for Alim, which is the undergraduate course.
Yes, my lord.
Kamil, that is postgraduate course. Fazil, that is junior research programs and other courses.
That's right.
So obviously, the Madrasa Act is made in pursuance of the power conferred by entry 25 of list 3.
Yes, my lords.
That is subject to entry 66 of list 1.
That's right, my lord.
Because that part, which is really subsumed in the UGC Act, would therefore stand excluded from the Madrasa.
That's right. But my instructions are that we have applied for this recognition. We have applied for recognition post class 12, my lords. We have applied for recognition post class 12. So at this point, we don't run post class 12. So right now it is 1 to 12.
Goes on assumption that if some student after 12th class wants to pursue higher education within the madrasa, then the higher education is within the domain of the central government. There is already UGC Act.
But do the madrasas confer any degree after high school, like, a Bachelor of Arts, Bachelor of Science, or a master's degree?
They have to take affiliation.
They grant certificates, my lord.
They grant certificates which somebody assumes that it would be equivalent, but it has no legal basis to say that.
It is a certificate.
So the High Court should not have, with greatest respect, should not have entered into that area.
Where did the High Court get this, that they are conducting instruction on undergraduate courses?
To have affiliation for that, and that's not there.
They are just breaking this down provision by provision and therefore saying that the provision is unconstitutional. There is no factual material before the High Court. I think we'll address your lordships on this portion, ma'am, on the UGC part, ma'am.
Come back to section 9A.
Yes.
At volume 4A, page 37. Right? Now, 9A says,
yes,
to prescribe courses for instructions, textbooks and other books and instructional material, if any, for Taitanya,
Yes.
Fokania, Munshi, Maulvi. Now they say Alim is undergraduate. Kamil is postgraduate, I think.
That's right, Manoj.
Yes.
Right? The High Court says Alim is graduate, Kamil is postgraduate, Fazil is junior research fellow. Now, anything which falls within the purview of the UGC Act would therefore, the Madrasa Act would be subservient to that.
My lord.
Unless it receives presidential assent.
And this is what we have applied for. We have not.
No, but therefore, one thing is very clear, that unless there is either the UGC grants affiliation to those institutions or they comply with UGC regulations, no educational institution can confer any degree or carry out any course of instruction which is in conflict with the UGC Act. Because UGC Act in Professor Yashpal's judgment says no institution can confer a degree.
Yes.
Unless you are affiliated as a university, unless it's a statutory university or affiliated as a team.
Confer a degree, my lords. We are conferring only certificates, and may I just show you where we apply for permission? Until we get that permission, we will not be conferring any degrees of any sort. Please see page 847, my lords. Volume 3A. This answers your lordship's question. This is what we have done on this portion. On the higher education portion, which the High Court, my lords, respectfully is only extracting the statutory provisions. Yes, so volume 3A.
847.
Page 847.
That is about considering the pay scales of teachers.
My lords, no, my lords, this is volume 3A, my lords. Your
3A.
lord, yeah.
You got 3A.
3A, my lords. Page 847, my lords.
That is that memorandum of 26th of June 2001.
No, my lords, this is dated 26 June 2001.
Yes.
Yes, my lords. Granting status of university to Government Arabic College, Rampur, after its upgradation and the difficulties regarding providing pension facilities. So this is our letter of request, my lords, to the state, that this recognition may be accorded, my lords. And that this may be.
You may not be conferring a degree.
My lord.
You may be issuing a certificate. For example, Alim graduate,
yes,
Kamil postgraduate. What will be the legal authenticity of that certificate? Will that student be called a graduate on the basis of that certificate?
My lords, the student would have been educated.
Just make us understand this part.
Yes. And we will not be in conflict with any UGC regulations simply because a degree is not being conferred.
Okay, tell us one thing.
My lord.
You have been issuing this certificate past how long?
No, since when? So
Now,
I'm just
take this. You have issued a certificate to a student studied in madrasa, Alim, graduate. He wants to do post-graduation somewhere outside this. Will that certificate be valid?
No.
For to seek admission in a postgraduate course?
No, my lords. Because the equivalent recognition is not granted, and therefore, my lords, I'm showing these letters where we are seeking to achieve that recognition, and that has not been accorded yet.
So you have applied with the UGC?
Yes, my lords. The state government, my lords, may please see, my lords. I started at pages 847, volume 3A, my lords. And your lordships may please see. Then the next document is 850. Again, to the Secretary of the Government of UP, my lords, where we requested, this is dated 14th January 2002. So we have been soliciting this recognition since then. Since we have not received it yet, we are not granting any degrees. Please see, my lords. Subject constitution of expert committee for study regarding the classification of madrasas on the matter of granting status of the university to the Arabic College Rampur after upgrading the same.
But this problem has cropped up for you only after 12. Till 12, there is
Yes, my
no
lords.
problem.
Till 12, 1 to 12 is already provided for, regulated and administered. This is only post 12, my lord. And in reference, my lords, your lordships will please see, we have asked for the classification and constitution of the committee, my lords. And we've asked for the committee to meet. And 854, my lords, is asking for recommendations of the expert committee regarding this classification of madrasas on the matter of granting of the status of university to the Arabic College.
Out to the High Court that degrees are not being conferred.
I'll have to take instructions on that, my lords. Was it pointed out?
Examining these.
That the High Court did not hear us on this portion, that it in fact only arrives at its conclusions by looking at the statutory provisions. So there was no contradiction with any UGC guidelines because we had applied for the recognition and it has been pending. And since we didn't grant degrees, we were not contravening any regulations in any case, my lords. My lords, this part of the record where we are applying for this recognition, which is the only papers that would have been before the High Court as well, since 2001, is not considered by the High Court. Neither were we heard on this argument, on this issue, nor were these documents considered.
area which really we need to look at carefully is this. If you look at sections 22 and 23 of the UGC Act,
My lord.
and for the purposes of this section, right of conferring or granting degrees shall be exercised only by a university established or incorporated by or under a central act, a provincial act, or a state act, or an institution deemed to be a university. That's section 3.
Yes, ma'am.
Under section 3, or an institution specially empowered by an act of parliament to confer or grant degrees. All right. 2. Save as provided in 1, no person or authority shall confer or grant or hold himself or itself out as entitled to confer or grant any degree. 3. For the purpose of this section, degree means any such degree as may, with the previous approval of the central government, be specified in this behalf by the Commission, that is the UGC, by notification in the official gazette. In other words, one thing is very clear, that the State Act does not constitute the Madrasa Board as a university. It's not a university.
It does not.
Therefore, it cannot confer any degrees. Therefore, perhaps the provisions of the State Act, insofar as they authorize the Madrasa Board to confer degrees, may be in conflict with Section 22 of the UGC Act. The other part, secularism and all that, we will hear them.
Yes.
But this part, maybe, just reflect on it a little bit.
Yes. Yes. I follow, my lords.
23. For the purpose of this section, degree means any such degree as may, with the previous approval of the central government, be specified in this behalf by the Commission. So suppose the UGC says BA, BSc, BCom, MBA. The Madrasa Board cannot confer those degrees, because then that would be in the teeth of 22 and 23. So we'll have to look at what degrees the UGC has specified under 22(3). Those they cannot confer.
Yes.
If they are operating outside this, there is no bar at all.
My lord. My lord.
So if the UGC has not enlisted Fazil, Kamil, all this Alim, then there is no conflict.
But my lords, for the last, since 2002, we have been requesting, we have been applying for recognition. That recognition never came.
Right.
Since the recognition never came, we never conferred degrees. Therefore, a violation doesn't exist.
But no, we are looking at the statute. We are not so much concerned with what you are doing.
With the effect, yes.
Challenge was to the statute. That's the that cannot depend on how you have interpreted it.
Yes, I follow. Lords, on this, I'll have to take instructions, my lords.
You can reflect on it.
Yes. Yes, my lords.
All right. Can we close then?
Yes, my lords.
Thank
Grateful,
you.
my lords. I'm very grateful. Your lordship.
Who will argue next?
When your lordship is considering this, please see page 130 and 131, these rules of recognition which have been framed, my lord. The government has framed these rules of...
Which file?
This is the same, my lord, volume 4A. Yes.
4A, 1987.
Volume 4A, containing the documents, etc.
Rules.
But this has not been specifically repealed, and this deals with the grant of recognition. Please see what happens here, my lord.
These are referred to in the statement of objects and reasons, actually.
Correct,
This
correct.
1987 rule.
Correct. Now, these actually deal, the state is granting recognition. And my lord, we are actually dealing with only students up to class 12. So if once your lordship sees these rules.
Who's appearing for the Madrasa Board, actually?
I am for some teachers.
Mr.
He's there in online. It's R4 is the Madrasa. He's online, Anas.
For whom?
No, for the Madrasa Board, because the Pradesh Madrasa Education Board.
Nobody.
It's a state board. So they are responding.
So these rules shall be called the Uttar Pradesh Non-Government Arabic and Persian Madrasa Recognition Rules. These rules shall come into force with immediate effect. After the enforcement of these rules, all previous government orders issued shall be deemed to be cancelled. The purpose of these rules is to ensure proper functioning of non-government Arabic and Persian madrasas, payment of full salary timely to teachers and other staff, and to make arrangements for secured service. For the recognition of boys, girls, madrasas, applications will be received by the registrar Arabic Persian. The fees.
So these are the 87 rules.
Correct. So this is recognition fee for Tatina, this is class 1 to 5. Then Fokania 6 to 8. Then it is, my lord, for Munshi and Maulvi, that is class 10th, and recognition of Alim, that is class 12th. Then it is Kamil, which is actually undergraduate, and Fazil is postgraduate. But actually on the ground, we are only operating up to Alim. All these madrasas. Actually, they are only operating up to Alim.
They don't operate beyond Alim.
Correct.
And Alim is what? Undergraduate?
Alim is 12th. 12th.
Alim is 12th.
12th. So actually on the ground, they are operating only up to Alim. We will seek instructions, my lord, as your lordship has put it to my learned friend. We may not have that much difficulty about not violating the UGC Act at all, my lord. We have to enter. Yes, we may not have.
Page 135, it says degrees equivalent to Fazil, Kamil, Alim, Maulvi, Munshi, Hafiz, and Arabic or Persian issued by any university or the educational institutions equivalent to the university shall be valid. So there may be equivalence of degrees given by universities.
Correct.
Under state or central act.
Correct. Those shall be valid. And then, my lord, separate, under clause 6 at 131, my lord, we have to give separate applications for recognition of exams, etc. Then recognition shall not be granted.
Mr. Patwal, you've got it. Anything more than what Dr. Goswami?
I wonder if those 3-4 documents were pointed out, my lord, then I have nothing more to add. One is that 30th May 2018 government order, which was issued for implementing secular education and applying only NCERT textbooks. That is by the state. That is at page 888 of volume 4A. Triple eight.
Volume 3A, I think.
Volume 3A, sorry, 3A.
This was 15/5/18, I think.
888. 888. This is the 15th May 2018 document. May 18. Where the board decided, my lord, regarding implementation of NCERT textbooks for teaching modern subjects in madrasa, recognized by Uttar Pradesh Madrasa Education Board, with the aim of bringing educational upgradation, standardization, and uniformity in the Arabic Persian madrasas of Uttar Pradesh. It has been decided in the meeting of the Uttar Pradesh Education Board dated 15/5/18 that in order to ensure uniformity.
We saw that.
Yes.
Dr. Menaka to show.
Yes. Then this is followed, my lord, on the very next page, 30th May 18 is the letter from the principal secretary at page 889.
Yes.
Where at 890 at the top, it is said that it has been decided by the board that due to making medium of teaching Hindi or English other than Urdu, it will be easier to connect students with the mainstream. Accordingly, the Madrasa board has decided to make amendment in the regulations of 16 to this effect. Then 18 amendment was shown, my lord, to your lordship, my lord. I was there at that time. Then, my lord, the only other thing your lordship needs to see is the recommendations which was made at page 915 on 12th October 21 by the board to the state government, where we said make all these subjects compulsory from 1 to 10.
And that we saw that item 7.
Correct. Item 7, clause 2. After extensive discussion regarding the curriculum implemented in madrasas, the council unanimously approved the inclusion of elementary maths, elementary science, history, civics as compulsory subjects from first to secondary level. So, my lord, the whole submission is that if it has to be made better, then these recommendations can be accepted. The government has the power to issue directions.
The directions that we will actually subject to constitutional validity, because government does have a vital stake in ensuring that these children who go to the madrasas come out with proper education, because they are spending 12 years of their life.
And these acts Otherwise, Lord, your lordships is aware, there is a CBSE Act, there is an IC board, there is an ICSE board. These boards, in fact, this was bringing it in conformity with the mainstream, Lord. By striking it down, it has not served the purpose of regulation. Yes, that's good.
Thank you. Anybody else? Mr. Anas Tawir, no?
Tanveer, my lord.
Tanveer. Now, is the board conferring any degrees, diplomas, what does the board do actually?
My lords, the board confers three certificates. One is for the Kamil. I'll just, my lords, may kindly take my counter affidavit, which is at page 770 of volume 3. Am I audible, my lords?
Yes. Volume 3, right?
Yes, my lord. 3A, my lords, is page 770.
3A.
Yes, ma'am.
Right.
My lords, different certificates are Munshi, Maulvi, Alim, and Fazil. Munshi and Maulvi is recognized as equal to High Court, to High School, and Alim is recognized as intermediate.
Already, sort of perked up. What's equivalent to a high court?
My lords, my apologies, my lord.
Where were you reading?
My lords, it is at just a moment, my lords. My lords, paragraph 8 of my counter affidavit.
Counter affidavit filed before the High Court.
Yeah.
No, my lords, my affidavit before this court, my lords.
Yeah.
Paragraph 8, my lords.
776.
Counter. Page number given is of the High Court counter.
That's what I got the impression. In the High Court of Judicature at Allahabad, sitting at Lucknow.
Yeah. My lords, my deepest apologies. There's some problem. My lords, may kindly take volume 3R, page 28.
3R. There is no 3R. Volume 3, respondent PDF. All right. That is volume 3.
Yes, my lords.
Page?
Page 28, my lords. It starts at page 28.
What is this document that you are referring to? This counter affidavit on behalf of respondent number 4.
Yes, my lords.
Yes. Volume 3, page 28.
Yes.
Sorry, page 17. And what are you referring to?
My lords, paragraph 8, my lords. This is running page 33.
8.
Yes, my lord.
Which paragraph is referring to?
May I read it, my lords? My lords have it.
Submit, yes.
Yes, sir.
Para 8 at page 21. Na?
Yes.
Examination of Munshi and Maulvi, which are held by the registrar, Arbi Farsi Examination Uttar Pradesh, have been given recognition by the state government, treating to be equal to high school. And similarly, the examination of Alim has been given recognition by the state government as equivalent, as equal to intermediate.
Intermediate. And my lords, to answer your queries, my lord, this paragraph 10, my lord, it says the students of recognized madrasas from UP Board of Madrasa Education may take admission in the graduation course on the basis of alim certificates issued by Madrasa Education Board. Apart from the UP Board of Secondary Education, the Ministry of Personnel, Public Grievance and Pensions Department of Personnel and Training Establishment section has also accorded equivalence to the aforesaid certificate of alim equivalent to senior secondary examination certificate through government order dated 23/2/2010. Further, my lords,
Are not awarded degree by the board. These are not degree courses, you say.
my lords, the certificate of Kamil and Fazil are given at the end of the board. The state government does not provide any grant or aid in imparting the education of Kamil and Fazil degree. And they are not awarded degree by the board. my lords.
All right. Thank you. Anybody else?
Few minutes, my lord. There is one petition filed by the clerical staffs of the aided madrasas. In each madrasa, there is one sanction post for clerical staff. My lord, since submissions have been made, I'll not go into that, my lord. A lot of emphasis has been given in the judgment. 70% judgment is based on secularism. That's now secularism, your lordship has dealt with differently in different subject matters. When it comes to educational matter, your lordship has taken a line. When it comes to election matters, there are judgments. So what you can say, what you can't say, what is communalism, what is secularism. When it comes to, my lord, I have given this written submission.
What is the meaning of Fawqaniya? Fawqaniya is 1 to 8?
Fawqaniya would be 6 to 8.
6 to 8.
6 to 8. Maulvi would be 10th, and Alim would be 12th. 11th and 12th.
Just 1 second. Fawqaniya is
6 to 8.
Yes.
Alia is 9 to 12.
Alim.
Alim would be 9th and 10th.
Alim.
Alim is 11, 12.
Is there anything like Alia?
No. Alia is some university, so there is something. There is some mention of Alia also in this. So Alia is something else, my lord.
Entertainment industry.
But there is, your lordship is right.
There is something like Alia.
Give us some clarity, Natral.
Munshi and Alim.
All right,
Munshi
now
is 9, 10. Combined, they are called Alia.
1 second. 9, 10th is
Munshi and Maulvi.
You start with Fawqaniya.
Fawqaniya is 6 to 8.
Fawqaniya is 6 to 8.
Then
If your lordship is having page 131, Tetania is 1 to 5.
what? 1 second. Where do we get it? 130, page 131.
131.
Of volume 3.
Of volume 3, volume 4A.
131.
Yes, of volume 4A.
Volume 4A, there's no.
Actually, Mr. Patwalia, are you on volume 3R? Do you have this volume?
Yes, yes, I can go to 3R. Just give me 3R.
Come to page 26.
26.
Here's one from Chaitanya.
So this makes it clear.
Then comes Fokania.
Yes.
That is, I'll see this.
Yes.
See, 125.
Which page are you on? Volume 3?
Yes, yes, yes.
PDF 26. Chaitanya 125.
Absolutely right.
Paukania 6 to 8.
Correct.
Munshi and Maulvi 9th and 10th.
Correct.
Alim 11th and 12th.
Correct.
Kamil, Fazil and other courses.
So Kamil is undergraduate and Fazil is postgraduate.
Right. And in his reply, he has referred to for the purposes of Alia classes 9 to 12.
Correct. So combined of Munshi and Alim, it is called Alia.
Okay.
9th to 12th combined is Alia.
Okay.
Perhaps the 2016 regulations also give them a lot. That might also give clarity.
2016 regulation.
Regulations, it's found in 4A, page 148, my lords.
Of volume 4A, page 148,
That's what
the regulations also define all this.
That's right. The regulations specifically give them.
Now tell us, these regulations are made with the prior approval of the government?
Yes.
Under which, where does the government get the right to prior?
Enacted by the government, my lord, and they say
no, they've been made following
with the previous approval. If your lordship will see page 148 at the top, the following Uttar Pradesh, page 148, the following Uttar Pradesh non-government Arabic and Persian Madrasa Recognition, Administration and Service Regulation 16, which the Board of Madrasa Education has made in exercise of powers under section 20 of the Act with the previous approval of the state government, is hereby published for general requirement under 20. So this is under the 2004 Act that these regulations have been made. Volume 4A. This is volume 4A.
Your Lordship, please. Yes. Lordship, what I was submitting, I have given this written submission 7-8 pages. The 3 points that I have taken. One, because the High Court has basically relied upon the concept of secularism and applied this principle without getting into all these details which your lordship, the submissions have been made from this side, madam. So my submission is that
see a law per se regulating an institution belonging to a particular community does not ipso facto offend the principle of secularism.
That's right.
I'll give you, for example, you have, say, the Hindu Religious Endowments and Charitable Institutions Act, first of which was dealt with in the Shirur Mutt case. Such a law does not, for instance, there are laws providing for the proper administration of religious institutions run by Hindus. That does not offend secularism per se. Those are there in all states, from Maharashtra to Tamil Nadu. Now, therefore, what we really need to see is this. High Court says that this completely offends the principle of secularism. You know that Article 30 enables linguistic and religious minorities to establish institutions of their choice. They are not confined only to teaching their religion. For instance, a Zoroastrian institution or a Buddhist institution can teach a course in medicine also. They can teach engineering.
Right.
There's no compulsion that, say, a Buddhist institution must teach only Buddhism.
That's why minority medical colleges.
That's right. Therefore, 30 also contemplates that you can teach your religion as well.
Why not?
The bar is under 28, that no institution receiving aid from state funds shall sponsor any particular religion. That's what 28.
Then at that stage, because the word term religious instruction has been used in Article 28.
Right.
And there is another term which came from Aruna Roy, religious education. So the High Court has gone into an interpretation saying that the madrasa education is religious instruction. So that is the problem.
Or religious worship.
Or yes, madam. So the term religious, putting this syllabus which your lordship has gone into in last 1.5 hours. Now, is this a religious instruction or it is mixture of science, maths, even religious teachings which will fall into religious education, certain portion?
Once that institution receives state aid or funds from the state,
yes,
it cannot provide religious instruction.
My lord, religious education. That's what Aruna Rai says.
No, but 28(1) says
religious education, your lordship, that's the reading of Aruna Rai. Let's see if you are.
But the board is not imparting any religious instruction at all.
That's
basically a regulatory board.
That's the submission, and that's why, my lord, the Aruna Roy says that's a very thin line. Your lordship may have this. This is at page. I'll just take it to volume 5A. 5A, page 2459. Just read only one paragraph, my lord, and then I'll come to Xavier's one.
That's okay. We'll read Xavier because we've dealt with all these judgments in the recent past.
I'll just point it out, the page numbers, my lord.
We are really concerned with the facts.
2459, my lord. A distinction thus has been made between imparting religious instructions, that is teaching of rituals, observances, customs, traditions, and other non-essential observances and or modes of worship in religions, and teachings of philosophies of religion, with more emphasis on a study of essential moral and spiritual thoughts contained in various religions. There is very thin dividing line between imparting religious instructions and a study of religion. A special care has to be taken of avoiding possibility of imparting religious instructions and in the name of religious education or a study of religion. So my submission is, my lord, your lordship has already seen the syllabus. Your lordship has seen the resolution passed by board. This in no way can be stretched to the term where it would fall under religious instructions. That's my one submission, my lord. Second submission, my lord. Once we are dealing with the term secularism vis-a-vis educational institutions, my lord, I have set out in details in 2 pages impact of Article 25, 26, 29 and 30. Both will have to be, all impact of all these articles will have to be seen and the judgments related thereto. My lord, one paragraph in Xavier's, my lord, only 5 lines, my lord. 5A, page 388.
Page
388, my lord. I'm just cutting short, my lord. In the middle, my lord. We fail to see how affiliation of an education institution imparting religious instructions in distinction with secular education to pupils as visualized in 28.3 would derogate from secular character of a state. Our constitution has not erected a rigid wall of separation between church and state. We have grave doubts whether expression secular state, as it denotes a definite pattern of church and state relationship, can with propriety be applied to India. It is only a qualified sense that India can be said to be secular state. There are provisions, and then Dr. Radhakrishnan's statement on secularism has been quoted. So this is Xavier as far as 28 is concerned, my lord. Article 28 is concerned.
In fact, just see that previous para also between classicum B and C.
B and C, my lord. A state cannot insist that children belonging to religious minority communities should be educated in state-maintained educational institutions or in educational institutions conducted by majority. A state's interest in education, so far as religious minorities are concerned, would be served sufficiently by reliance on secular education accompanied by optional religious training in minority schools and colleges. If the secular education is conducted there according to the prescribed curriculum and standard, Article 28.3 implies that religious minority administering an educational institution imparting general education has the liberty to provide for religious education in the institution. The continued willingness to rely upon colleges conducted by the religious or linguistic minorities for imparting secular education strongly suggests that a wide segment of informed opinion has found that these colleges do an acceptable job providing secular education. The state conceitedly has power to regulate and control education of its children, but it cannot, by general law, by compelling attendance of public school or college, preclude attendance at the school or college established by religious minorities.
We'll then close here.
Your Lord,
so that
my
we can
submission
hear
is
the
there,
others.
so I have put down on this.
Yes.
Lords, just three short points. My lords, your lordship, just keep it in mind for the context. Just three quick points. Just three very quick points. That gives the context of the background of madrasas. One, these are traditional schooling schooling arrangements and so on and so forth, going all the way to what is considered to be beyond school. Well, it's the concern of the schooling system is only up to the NCRT level, the school level, which is your lordships have seen till the Alim level. But the Kamil and Fazil is beyond. Now, Kamil and Fazil degrees cannot be given because that's very clear from the UGC Act. And my lords, the degrees can't be given because Madrasa board or the madrasas are not universities. Degrees can only be given by universities.
That is exactly what, before you came, you were just pointing this out.
Since these are not universities, and what is happening then, and has been attempted over the years, is that universities like Aligarh have sought to give equivalence to Kamil and Fazil, to say that we will treat you as a BA or we will treat you as an MA, so that you can get admission into university on the level at which you have reached in the madrasa. Jamia, Aligarh have attempted this over a long period. Another method that was sought was for a university to be established to which all these madrasas would be affiliated. The university would then give the degrees. That's how they would overcome this whole problem of recognition across the country and across the world. That if you have a Kamil and Fazil, how would you be recognized as an equivalent? You either have an equivalence or you actually have a degree which is given
affiliated to
an affiliated
Jamia or whatever.
That's right. So, Maloj, that's that.
But you are very clear in your mind also.
Absolutely.
That Fazil or Kamil cannot be.
They can't be called degrees.
And they cannot award degrees. Also because the board of madrasa is not a university.
It's not a university.
That's the reading of section 22 and 23. I think on that, Mr. Natraj also will have.
Maloj, one point that rises is about Article 28, the aided institution. Now, the aided institution has to be fully aided. What happens in a madrasa is only the salaries of the number of teachers who are given to each madrasa is paid. Nothing else is paid. Hostel fees, hostel food, hostel, even travel during vacation, etc., is managed by the madrasa itself. So it's not a fully aided institution. So if at all there's an issue about instructions and teaching of religion, that would not fall foul of 28 because this is not a fully aided institution. So these are two very important points. But the rest follows my learned friend on secularism and etc. Your lordships are already right. Greatly obliged.
Thanks. Dr. Singhvi, anything you want to supplement?
5 minutes. I'm not 7 minutes. I'm unfortunately not here to assist your lordship at the beginning. I was supposed to open, but I'm sorry, I was on my legs. Well, it's point number 1. I'll be very brief. All has been covered by learned friends, comprehensively covered everything with Guru Swami Malas. But the crux of the larger issue is you suggest ways to improve, suggest regulation. Banning is per se wrong, unconstitutional. That's the perspective which the High Court has misdirected itself with the deepest humility. The perspective that you can do much more by regulation, improvement, suggestions, reform. Here is a ban order, Malas. Let's not forget, your lordship, dealing with a ban order. That's point 1. Point 2, my lord, Malas, notice this argument specifically of mine in the interim order at page 102, which is my lords, the Honorable Chief Justices.
102 of volume?
Of Supreme Court, sir. Malas, the order of interim order, where is it now?
Volume 2, volume which volume is it?
Volume 3A, page 102. Which has the, keep showing it down. It has the specific para. If that perspective is accepted, which has to be, then the whole order must be set aside on that short ground. Malas, you can say that this particular instruction, Malas, let me not be, Malas, I'm trying to be, Malas, very particular. Take, for example, there are very, very good traditional forms of learning in our, Malas, various Gurushalas, our various, Malas, Gurukuls, etc. Now, if you teach the philosophy of Hinduism, if you teach the philosophy of a Sanskrit Pathshala, etc., you cannot ban it. There may be infirmities there also. You have to suggest whether this is a ban order. There is no doubt about the operative direction. That's the first point, Malas, on which alone it can be set aside. Second point, 28.1, ask yourself the question, Malas, why was 28.1 enacted and a full stop not put after 28.1? Well, the simplest thing would be put a full stop after 28.1. Let's kindly see the structure of the constitution. Your lordship did not stop at 28.1. Your lordship went ahead only for a particular reason for 28.2. The text is clear. It is, Malas, actually a direct exception and derogation from 1. The question is why? Now, Malas, we don't have time, but we can give a compilation of the debates. This, Malas, was only to ensure this particular, I'm not saying, this is important, the second point. My categorical cases, I do not impart religious instruction. I should not be misunderstood. But were I to impart religious instruction, or were I to incidentally trench by imparting some religious instruction, that's my, I don't want to be, it's very categorically I'm saying, it would be protected under 28(2). Obviously, Malas, difference of degree make for difference of kind. Tomorrow, Malas, I start teaching only rituals. And I say I'm a very good institution, I'm only teaching rituals. You will strike it down. It's common sense.
To 28(2) administered by the state, which is administered by the state. 28(2) has no application.
No. I am saying, Malas, where your lordship prohibited administered by state in 28(1). Your lordship made an exception there, therefore A for sure. If you are not administered by the state, that exception will be more alive and kicking. Well, 28(1) is for state funded. An exception is created for 28(2), which has to be the same subject. Suppose you are outside the very ambit, it is A for sure, much ahead of 28(2) also. That's the point I'm making. Now, Malas, my point number 3 is that, Malas, in Aruna Roy, there are various passages read some by my friend. I'm not going to repeat a word, Malas, but just see one passage of my Lord Justice Dharmadhikari at what page is this? 2458, volume, I believe, is 5A, 5 capital A, to pinpoint the PDF or the relevant page. Placitum, Malas, EF is 1 para, and next page, Malas, 2458 is volume 5 capital A.
Yes.
It recognizes that while you cannot do religion, well, I'm not imparting religion, I'll show the syllabus. But were I to, as I said, impart, this clause and this judgment recognizes that there may be religious instructions by minority educational institutions established and are protected under 28(2). The point I just made, judicially recognized in the Aruna Roy at 2458-2459. Now, Malas, keeping these 3 basic points in mind, just note a few pages. They have been covered, so I'm not going to argue them, but I want to pinpoint the pages for your Lordship's kind consideration. 1, Malas, not that your Lordship will now decide everything, but this is a little, Malas, unfortunate. Please note para 33 to 35 of the impugned order. This, Malas, is the most strained interpretation of locus your Lordships can get. A writ petition is filed. According to me, the finding that he can maintain the writ petition is the clear evidence that he cannot. And yet locus is found, Malas. I will not read it for saving time. Just make a note and read para 33 to 35.
We made a note earlier.
If this, Malas, is locus standi, to have a ban order on hundreds of institutions, then, Malas, a free for all. And, Malas, lastly, 2 more things. Just 1 minute more I take. Please note the syllabus which has been pointed out to your Lordship. Note these 2 pages, Malas. 190, volume 3A, 892 to 896. Because the words are classical words for the modern subjects. Ganit, Vigyan. Please repeat, Malas. 892 to 896. And, Malas, lastly, the amendment is again been ignored. The amendment makes it clear that, Malas, you incorporated modern subjects by an amendment which is in your Lordship's volume 4A at 169. The old one didn't have it, that has been made the point. I'm deeply obliged.
Lord, I beg to appear, your Lordships, in item 1441.4.
Small note now. We'll conclude this side now. Give us a small note.
Lords,
my submissions
I'm
are
mentioning, my Lords.
Yes, sir.
Lord, item 57 and 58. Lord, this is the matter pertaining to
National Highways?
No, my Lord. Civil judge examinations in Rajasthan. My Lord, where 0 to 15.
We call that English paper, I think.
Yes, my Lord, English paper. 0 to 15 were the maximum number of marks. My Lord, your Lordships will please to direct the papers to be here, my Lord. Lord, in compliance with that,
you're mentioning the Hydra matter as well.
Take a little break for 5 minutes and come back and do a little more work and I just put it to my learned brothers.
Whichever, my lord, otherwise it can be taken up tomorrow also.
Lord,
I must tell your lordships one thing, Lord, the papers which were called for from 0 to
15, they're in 7 trunks.
They are in 7 trunks, my lord. So
Did they have the access?
Time, bhai. 40 seconds.
I'm appearing for the High Court, so I'm not, my lord, taking any adversarial stand. But whichever way, my lord, it
And so far as this partner is concerned now, the this side is over.
Correct.
Now we have to call upon Mr. Natraj. Mr. Solicitor, just give us 1 minute, only just logistical. So we can do this.
Yes.
Before we begin the part heard tomorrow,
Yes.
we can hear you because we'll wrap it up in an hour. We'll
Very
do you and Guru and Swarupama that you can see how you are distributing the time, and then we'll start the part heard.
Yes, I'll seek about 45 minutes.
Sorry, Guru.
45.
You're not one of those 45-minute council. We'll see. So tomorrow morning. So let's do this. Since there's such a large crowd of lawyers who want to mention, we will not disappoint you. We'll continue on. We have 41 is over now, in the sense we have kept it tomorrow. Okay. Let's quickly run through the board. Let's see 42 onwards. 42 now.
Fair enough.
All right, one second, just 1 second now. We'll call out number. Sorry, Guru.
Tomorrow.
Yes, 41 in it. Tomorrow, and mark it in the board at 10:30. But Mr. Natraj, it will be marked in the board at 10:30.
Very well.
There are about 2 or 3 fresh.
Immediately after the fresh matters.
Fresh matters.
Very well.
So then you are relieved of.
Very well.
All right. 1 second.
marital rape afterwards. Marital rape after this.
After this.
We
Okay,
will
item 42.
Pay the lordships.
Holding order that till further orders, Justice Jain. Now we are saying, well, there is today time left for that main decision. Let that ad hoc situation continue. We both agreed.
Is Justice Jayannath's appointment to come to an end?
No. What is the age? 1 minute. Age problem is there. There is a general rule about 65 years.
Because I remember Mr. Jain was appearing for the...
Yes,
He and I agreed.
You both said
When your lordship is recorded in the order. Now, I know that normally a lordship will not do it, but ad hoc it's in the public interest that it continues till such time that matter is decided. What is the harm? Both have agreed. My learned
I would,
yes. So it will not be bound by that technical rule of 65. That's all.
What is the date of the order? 18th October.
Will give, yes.
Order date is
4th August 2023. And followed by, because the second order is 18th October. What my lord is referring to is the second order, but the order appointing is 4th August.
4th August, is it?
Yes.
And your lordship make it by consent again, which is very fair, Both sides.
By an order dated 4 August 2023, Justice Jayantnath, former judge of the High Court of Delhi, was appointed to discharge the duties of the chairperson of the Delhi Electricity Regulatory Commission. Brackets DERC. Full stop. In order to obviate any controversy on his having crossed the age of 65 years, no?
Yes, brother.
Yeah, he will cross him. He will cross.
The appointment by consent, the appointment of Justice Jayantnath as to discharge the duties of chairperson of DERC shall continue, notwithstanding any issue in regard to age.
I'm very deeply.
I'm for the central government. I think Mr. Jain may have some instructions from the LG. I'm not aware.
Yes, in fact, I just mentioned Mr. Jain's name.
Yes. My lords, we were, my lords, agreeable both ways. If your lordships were to take a view that age of 65 is going to be sacrosanct, that in that situation, my lords, we would have suggested some other names.
No,
But
I
now
don't
that
think
you're
so.
not,
He's doing well, you know, he's been now familiarized with
It's
the.
necessary.
Repeated, you're not fighting on this, why should we fight now?
Yes.
Praise the lordships.
Is this an MA or what is it, Mr. Jain?
It's an MA.
It is an MA,
You
my
filed
lords.
an
It is
IA
a
by
MA
the
filed
government
by.
of Delhi.
Would
I'm
check
the
the
government
law,
of Delhi.
would dispose that.
It's an IA by the government of Delhi.
Disposed of. Disposed
All right, 43.
Lord, 43 is a question of law is whether there is evidence or not for the conclusion. I would take less than 10 minutes, Lord. Not 5 minutes, but definitely less than 10 minutes, if you can hear me, please. 2-page written submissions have also been given. Lord,
For the respondent, my lords, may consider having it after the vacations, my lord.
not after vacation. Lord, this has been, Lord, 7 times I've been jumped out of the queue, my Lord.
Friday? Friday will.
Obliged, Lord. Lord, may I request slightly higher up?
Plus 44 is that DCA award, which the concurrent findings of the tribunal, and 34 upset by 37 purely factual findings. The lodgers had kept it on a short date. In fact, Friday didn't suit me.
I'm
so
the
it was Monday
respondent.
today. And I'm for the petitioner. Would your lordships have it on the coming Friday, my lords?
Well, it's on a Friday. I mean, I have no problem. On a Friday, on the last working, this side, I don't know whether it will be over or not. I leave it to my lords. I'm quite happy your lordship takes it up on Friday and is able to deal.
Whatever, you, between the two of you, you tell us what you want to do. You want to take it up now? We can hear you for half an hour. Friday.
Let us leave it on Friday.
We'll take it up on Friday.
Grateful.
I appear for the state.
Is that
Arunachal Pradesh, my lord, that writ petition which is in file
For the
again.
petition, Mr. Bhushan.
involving the Arunachal chief minister, where virtually all the contracts in the
Can we
state.
keep it after the reopening on Monday?
All
Monday after the reopening, we'll take it.
46.
I already said 46, I appear.
One second, 46, 46.
My lords, I'm
I
on
appear for the
46. My lords,
respondent,
he's
Lord.
entered, he's filed a
I'm
counter.
here, Lord.
Respondent number 2.
But I filed a counter affidavit. Not, may I just say this at the outset? He's here. Unfortunately, Lord, I understand your lordship that issued warrant. There was a lapse. We should have appeared.
Mr. Luthra, you are in the, are you in the pressings of the court? You're for the member of the bar who's her former husband, right?
Yes, Lord, I'm here, Lord. I'm here for the gentleman. He's also present.
He's in court.
No, Ms. Luthra, you are away from the court right now, or what is?
I'm away from the court, Lord. Right now, I'm away from the court, Lord.
We'd like you to be there, Mr. Luthra, because it's a matter which is to be, sorted out between the two of them.
May I just say this,
Both
Lord?
of them-
On this issue,
both of
Lord,
them
on this issue,
drawn, and I think we have to put an end to this now.
Lord, may I just take a moment, Lord? That's a,
She's
Lord,
got
that's one
married,
aspect.
she's got married. Both members
Lord,
of the bar.
Lord, may I just point out not just one thing, and one aspect of the controversy, short, Lord. Here, Lord, there is no objection to the name being changed on the certificate, except that the gentleman whose name is to come with their consent and affidavit is not here. So, Lord, that would be a very odd situation. The second aspect, Lord, is.
Sorry, Ms. Luthra, I didn't, your voice was breaking. You have no objection
what I'm-
to change the name of the child.
I have no difficulty, Lord, but the only thing is, Lord, the only request I have to make is twofold. One, a lot of unnecessary, Lord, pleadings have been made, as also, Lord, the disclosure of the victim of the rape has been done, Lord, which your lordship knows is a cognizable offense.
Closure of the?
The disclosure of the name of the victim, Lord, the prosecutrix in the rape case, her name has been disclosed in the annexures to the pleading, Lord, that should not have been done.
She's not a party, my lords. And she.
Maybe not, but you can't disclose her name.
The sister-in-law is coming to court every
I'm
day.
sorry, I'm sorry,
Supposedly
Lord,
the
that's not the point.
Let's not,
Lord, how can you?
let's not get into any.
The law is clear.
There's a consent.
Not the, if my learned friend, Lord, this issue,
Luthra,
this
one second.
aspect need.
One second, Ms. Luthra is appearing, it's a good thing for us.
Yes, yes.
That, we'll be able to reasonable counsel, we'll be able to resolve this matter. Ms. Luthra, what is the way forward? You tell us.
Not the way forward is not so far as this aspect is concerned. Please record the statement. The name may be changed, provided your lordship gets an affidavit that her husband is willing to take the name. It should not be that we are doing something behind her back. Because today, I have not otherwise see the precedent. My ex-wife and I agree that her new husband's name comes in on the birth certificate. If he tomorrow says, I didn't consent, please consider the ramifications.
What we'll do is, Mr. Luthra, we will say that he will file an undertaking before us that he consents to the name being changed.
He will file an undertaking, Lord, that's fair enough. Matter can be closed. And pleadings to be, Lord, those pleadings which they've done, my friend may expunge and and I leave it at that. That's the only other thing I wanted. Matter can be closed today itself.
the name will be changed in the child's birth certificate with effect from now, right?
My lords,
Yes,
there's an
ma'am.
adoption deed that
Yes, Ashura, you are appearing?
My lords, there will be an adoption deed. If I could just, I have, we have looked into it. The adoption deed, the term ceremony under the Hindu Adoption Act has been done. Once I get a no objection from him, the adoption deed will be registered. After that, I don't need any change on the birth certificate and all. The birth certificate will, of course, be of the biological father. Only the adoption deed needs to be registered. That's right.
All right.
And
Yes,
that
ma'am.
direction
All
will
right.
be.
Mr. Luthra, what we will do is, you have a genuine concern. We will say that the present spouse of the petitioner, he will give his no, he will give his, he will file an undertaking in our court. Now, the adoption deed, which was dated,
It will have to
I'm
be
not
have to
on the
file
issue of
only
adoption.
after he gives an adoption. I have done the Dattavanam ceremony. Pictures of that I can present.
so, Mr. Luthra, we can record that your client will
I'm
give.
not objecting to it, Lord. I'm giving consent, Lord. If that is the case, Lord, I'm giving consent. Please record my consent.
All right, he gives his consent here.
Very well.
And then that's the end of the matter, really.
That's the end of the matter, Lord. That's the end, Lord. Prayer A is allowed, Lord. Prayer B is allowed. And if not, observation, Lord, pleadings have to be expunged. Lord, there's a lot of things which should not have been said.
What we will do is we will expunge all allegations which have been made by and between the parties in this proceeding. We'll say
Yes.
that in the spirit that this is the matter which is being sorted out between two former spouses, that they are not standing by any of the allegations here. Now, is there any other proceeding
Trial,
which
my lords, that will impact the trial. Because, my lords, that
will impact
Lord,
what?
the divorces are done. The divorce is done. Everything is done.
30 seconds. My lords, against me, my father, my brother, who is the present wife's husband, my uncle, my father, and my cousin brother. 6 of us and my sister. 6 of us are facing trial by the former husband.
On what charge?
376D, my lords. And 307. Because, my lords, when I caught them, when my entire family caught them in a particular situation.
That we can't
I'm
compromise.
not, no, therefore, my lords, one of the bail conditions in the matter was this, that I cannot approach the prosecutrix or the witness, which is why I have approached my lords. Because of the reason the consent can only come to my lords.
What is all right? What is Ms. Luthra? What is the prayers here?
My lords, the prayer is
Lord, the
only
prayers are two. Both are answered. Prayer A and prayer B, Lord, I've conceded to. Both are
Just give
answered.
us 1 second. We'll sort it out. It's a matter of family law. We'll just sort it out properly. Just give us
Page
1
41,
second.
Lord, page 41. Page
Just
41.
1 second, sir. Once, just don't. We are not in any hurry. Somebody's life is dependent
Page
on.
41, Lord, page 41.
Just 1 second. I have to first get out of the previous matter where I have to save the briefs. Otherwise, all my markings will go for tomorrow.
Page 41.
Just 1 second. Give me only 1 second. ये कौन सा serial number है भाई?
Lord, 46. 46, huh?
My lords, the prayer may be see page 41.
Actually, your prayer is in conflict with what you have just submitted. You submitted that there is no need to correct the birth certificate. Today, the problem is you want to go for adoption.
My lords.
And you need to draft an adoption deed.
My lords.
Now you read your prayer.
My lords, that can only be done under section 9(2) of the Hindu Adoption Act.
So
My lords,
therefore-
kindly see section 9, how it reads.
You have the Hindu adoption.
My lords, may kindly see the page of, my lords, on page N. Page N. Of my pleadings, my lords.
Just 1 second.
Page N.
N, my lords. Since he's alive, though I don't come in, he won't come under those 3.
Right? But this relief is, we can't grant you this relief.
My lords, the
We can record his consent.
consent.
9(2),
My lords.
his consent has to be recorded.
Very well, my lords. After this, I will be able to, the concerned authorities before my lords, I will be able to approach them with the adoption deed.
That's correct.
I will be able to do. But his consent, I cannot do because the gang rape matter, the trial which is going against me and my family members by the former husband and the sister-in-law, I won't be able to take permission from them because that's a...
I've
given consent.
My lords, the second limb of my arguments is this, my lords.
On that now.
My lords, the second limb of...
By taking up all these issues, you're making it more difficult for yourself to get an order here.
Lords, The reason
I'm giving consent, Lord. I'm giving consent. Please take my consent, Lord.
My
And
lords, the reason
close
I'm
it.
making these submissions are this in peculiar facts, if my lords could
Now
consider
just,
increasing the
now
scope.
just listen to the order. The petitioner, when were they divorced, by the way?
23rd
September 2016.
23?
September 2016.
By an order passed by the
Family court.
23 September 16, Lord. 23rd September, Lord.
Mutual consent.
By an
23rd
order
September
dated,
16.
1 second. By an order dated 23 September 2016, passed by the family court at Karkaduma
Karkoduma.
in case number,
I'll just, my lords, may kindly see the.
give it to the court master
The
title.
petition number, very
A decree for divorce by mutual consent has been passed, consequent upon which, full stop. The decree for divorce by mutual consent has been passed as between the petitioner and the second respondent. Full stop. The issue which forms the subject matter of these proceedings pertains to their minor son, right?
My lords.
Their minor son. Full stop. Both the petitioner and the second respondent have since married. Full stop. The petitioner, the present spouse, the petitioner has specifically stated that the present spouse, that her spouse is agreeable to the child being taken in adoption, by being taken in adoption. Full stop. Bearing in mind the provisions of section 9(2) of the Hindu Adoptions and Maintenance Act, 1956,